Appeal of the year 2015, your lordship.
Yes. This is second appeal of the year 2019. Second appeal, order particular you. I had given memo earlier. It was allowed, but not listed. No, it was not listed. One month before
limited matter adjust miscellaneous. This is a miscellaneous basis. Different types of matters are being dealt with. All the memos are being allowed, excepting those which are not supposed to be allowed. All other memos are being allowed, and this is the direction issued to the court. Depending on the urgency.
Second appeal 2014 matter.
Supplementary list item number 1 for judgment.
In the result, the writ petition is found to be devoid of merit and is therefore dismissed. There shall be no order as to cost.
Item number 2 for judgment.
Thus, from a conspectus of the analysis of facts and law made herein before, this court is of the considered view that the authorities should first notionally appoint the petitioner as reader in charge and thereafter as junior production officer, so as to treat his last pay drawn in such scale. His pension and pensionary benefits should be reworked and revised accordingly. Since the petitioner has also retired since 2014, necessary orders shall be passed in this regard by the opposite party authorities as early as possible, preferably within 2 months from the date of production of certified copy of this order by the petitioner. The writ application is disposed of accordingly.
Item number 3 for judgment.
Thus, from a conspectus of analysis made herein before, this court holds that the petitioners are not entitled to notional engagement as Sikhya from the year 2006 as claimed by them. Resultantly, this court finds no merit in the writ petitions, which are therefore dismissed. There shall be no order as to cost.
Item number 4 for judgment.
In the result, the writ application is allowed. The impugned order dated 21/11/2006 Annexure 9 is hereby quashed. The opposite parties are directed to act in terms of the observations made in this judgment and to refix the petitioner's last pay in accordance therewith and to release the actual benefits from the date they fall due without any further delay. Necessary orders in this regard shall be passed by the opposite party authorities within a period of 2 months from the date of production of certified copy of this order by the petitioner.
Item number 5 for judgment.
In the result, the writ application is allowed. The impugned order is quashed. The matter is remitted to the ADM Jonjor for hearing the appeal afresh after giving opportunity of hearing to all concerned and by specifically answering the contentions raised by the parties by citing reasons. The exercise should be completed within 2 months from the date of production of certified copy of this order.
Item number 6 for judgment.
For the foregoing reasons, therefore, this court is not inclined to grant bail to the petitioner. The bail application is therefore rejected.
Item number 7 for judgment.
For the foregoing reasons, therefore, this court is inclined to allow the prayer for transfer. It is directed that the proceedings in GR case number 684 of 2023 pending in the court of SDJ Malkangiri shall be transferred to the court of Learned SDJ Hindol. Learned SDJ Malkangiri shall transmit the record within 2 weeks, whereupon SDJ Hindol shall proceed in accordance with law. So, the GR is 160.
Item number 8 fresh admission.
Lord, I am appealing for
Item 8
Item 8.
yesterday I got the copy. I am for the opposite party. They have served only yesterday. It may be fixed any day next week for counter. Any day next week, I will file the counter. A counter next week.
Anyway, he has appeared. He seeks.
Yesterday only they have served.
No, then wait. Let Mr. Mahanti come. Yes, pass on.
Item number 9.
My petitioner is wife and he was residing in Malkanagiri, and father and mother were staying there. The opposite party, the husband, has filed under some 9 before the family judge for Jagatsinghpur, and the wife, after registration marriage, she is staying with her father and mother, and all are staying there, and the notice was issued in the address of Malkanagiri. The husband has
All right,
filed the
take
Jagasutra.
notice. Notice, stay
No.
for me.
I,
All right, stay.
oh, okay.
I do not take.
May I please? I would say petitioner is residing with
Take over, let for the vote.
with
Yes,
a
please.
with her mother at Jajpur. The opposite party husband has filed a case, divorce case in Family Court Bhubaneswar,
Take notice.
and I
Notice, stay.
focused.
Right now.
I don't know 11.
So covered by Dhananjay Chandrade case, my lord. First one is the only petition, my lord. That's why I have two orders.
This. Yes, Mr. Das.
Yes.
He has given two orders.
Yes.
First केवल single petition और बाकी वो सब जो individual applications representation. Yes.
I don't know 12.
Item 12. Yes.
Disposed of it.
It will be disposed. Item 12. Yes.
May I please, Your Lords? Advertisement issued by the CDPO. My lord, petitioner applied for the post of Anganwadi worker. My lord, the grievance of the petitioner is that, my lord, she is not the residence of that Anganwadi center, my lord.
Who?
Not the petitioner.
Not a resident.
Not a resident, my lord.
Yes.
Admittedly, she is not a resident, my lord.
Yes.
But she got married to one Ajay Kumar Givela of that village, my lord, that Anganwadi center on 11/7/2024, my lord. And my lord, she had applied for the residential certificate, my lord.
11/7/2024.
Yes, my lord.
When was the advertisement?
Advertisement is 12/7/2024, my lord.
So did you get a residential certificate?
But I have applied, but I have not gotten residential.
So, obviously. So the advertisement must have mentioned that you have to file your original documents by a particular date.
Yes, my lord.
So
And she has submitted her honorary application relying upon one residential certificate, though she has not attached it.
Hmm.
So, my lord, that must be
no,
not
let
of
us
that
see the
particular
order.
service area.
Was there any? So have you filed any appeal or what?
No, my lord. No appeal has been preferred, my lord. Appeal preferred.
Is it किसी होगा नहीं?
Lordship, direct I will prefer an appeal which may be disposed of within a certain timeline.
That liberty is always with him.
Even if you get the liberty from this court, you can always file an appeal. But the fact is, can the authorities relax the provisions of the advertisement? They
No.
cannot. They cannot extend the last date. So, you married into that in that village. You married in that village, so you became a permanent resident. You should have obtained a resident certificate.
My lord, I have applied, but they have not issued till.
So when did you apply? You married on 11th. The advertisement was on 12th.
After 12th, my lord.
ସବୁ ଜିନିଷ ଗୋଟେ ଭାରି କେମିତି ଗୋଟେ
After 12th, my lord. Admittedly, it is after 12th, my lord.
ଛାଡି ଦିଅନ୍ତୁ।
Lordship, liberty may be given. I can afford.
ଖାଲି withdraw କରିଦିଅ।
Well, withdraw with a liberty if any further actions, further cause of action, then I will approve this court. Otherwise,
That I do not have.
All right. Permitted to withdraw with liberty to approach this court if any further cause of action arises.
obliged, my lord.
I don't know 13.
Yes, it is. Yes, Mr. Manti, that matter. Where is the other side?
Yes.
He was asking for time till next week so that he would like to file a counter. I have.
মানে question হচ্ছে there are 3 matters are pending at Cuttack. 2 matters so far the CP is concerned, it is pending at Bhubaneswar.
Object, he can get it. Professional reasons at least.
Kindly hang a copy of it.
So, and another thing, what about any chance of settlement, mediation?
Settlement মানে we have go to any extent but they are not agree. ଏଇଠି କଟକରେ ମଧ୍ୟ ଆମେ ଫାଇଲ କରିଥିଲୁ ପ୍ରି ଲିଟିଗେସନ ଗୋଟେ କରିକି କନସିଲେସନ ବି କଲୁ ପ୍ରାୟ 1.5 ବର୍ଷ ତଳେ।
ତାହେଲେ you file your objection
ଏବଂ ମୁଁ ମଧ୍ୟ ମୋ ତରଫରୁ ଆଜି ବି ରାଜି ଯେ କନସିଲେସନ still then ପୁଅ ରାଜି ନୁହେଁ।
ସେ କଥା କହୁଛନ୍ତି ମୁଁ ଖାଲି କହୁଛି 15 ବାହାଘର ଆଜ୍ଞା 16 ଯାଇକି 17ରେ CRP ଫାଇଲ କରିଛନ୍ତି ଆମେ 22 ଆସିକି ଡିଭୋର୍ସ ଫାଇଲ କଲୁ 5 ବର୍ଷ ମେଣ୍ଟେନାନ୍ସ ଦେଲା ପରେ ଏବେ ଆଉ ଆମେ 5 ବର୍ଷ ଛାଡିକି ଗଲା ପରେ ଆମେ ଡିଭୋର୍ସ ଫାଇଲ କଲୁ।
Land counsel for the opposite party wants some time to file objection to the transfer application. Please this matter go to week study for
21st August.
21st August.
ଆଜ୍ଞା।
Is there any stay?
ନାଇଁ ପ୍ରୋସିଡିଂ ରେ ଚାଲିଛି ନାଇଁ ହେଇନି ଏଟା ଫ୍ରେଶ ମ୍ୟାଟର
Alright,
ଇନଫ୍ୟାକ୍ଟ 21 କୁ ଆସୁ ଫାଇନାଲ
Item number 13,
In item 13, your lordship had directed in view of the disputed questions of fact, the director to decide. In fact, he has informed, noticed the principal and the posting is on before. It has been fixed to tomorrow.
tomorrow. Learned State Council informs that as directed, the director has commenced an inquiry which is fixed to tomorrow.
I'm sorry, today it
It
has
is
been
fixed to
at
today.
4 p.m. Yes.
Hence, let's this matter next week. Parties, next week, not that
21st August.
21st August, parties to inform the court regarding the result of the inquiry conducted by the director. Interim order to consult.
Item number 14,
My lord, appearing on behalf of my senior KP Mishra, kindly if you could grant passover.
All right, pass.
item number 15,
Hello, President.
Item 15. The pass over.
item number 16,
Mayor Lordship, on behalf of Sujata Jain Advocate, the Passover.
All right,
Yes.
pass over.
item number 17,
Pass over.
item number 18,
18 वाला OP 7
Who's for the petitioner? You are the petitioner?
काउंटर
I am
पे क्या
for the
सबिंग
petition.
Yes.
No, your lordship had directed them to file counter up to it.
आई एम सबिंग मेल
Right now he's.
No, that direction was issued on 10th of July.
हेलो
So you when did you file the counter?
काउंटर हेड फाइल मैटर 27 जुलाई 24
27 July.
Right.
And impose cost. Why did you not serve the copy till today?
लास्ट ओकेजन ही हैड
No, so that is not the lookout of the court. That is not the lookout of the court. You will wait in the court till he appears and thereafter you will serve a copy. What is this?
लास्ट ओकेजन ये लॉर्डशिप है
No. Why? Last occasion means it was on 10th of July.
10 जुलाई मेरा
10th July.
Madam.
And today we are in 7th August.
मेरा
Tell.
and
So why will you not serve a copy of the counter earlier? You pay cost. Learned counsel for appearing for the opposite party number 7 submits that the counter affidavit was filed on
24 जुलाई लिस्ट एक लाई 24
file
जुलाई
again
24 जुलाई फाइलिंग
on 24/7/2024. But the copy thereof was not submitted, served on the counsel for the petitioner till today when the matter was called out. The counter affidavit be brought on record subject to payment of cost of rupees 500 by the counsel for opposite party number 7 to the Odisha High Court Bar Association. Yes. List this matter.
28th August.
Huh?
28th August.
28th August, rejoinder if any be filed in the meantime.
Item number 19,
I find the rejoinder also should have filed the rejoinder. I have already copies of it.
Is I go looking the name of Mr. Dev Sangupta be deleted from the court list. Yes,
Yeah, rejoinder copy has been served today.
yes. 2011 matter.
Tomorrow,
Yes,
tomorrow if you
Next,
not.
next week, yes.
next OT.
Learned counsel for the petitioner files rejoinder in the court after serving copy on the other side. List this matter next week.
item number 20,
Item 20, Lordship, I am unable to contact the client. I pray for Monday. I have informed the local council, Lordship.
Yes, yes.
20, Lordship, I am appearing for the petitioner. I am unable to contact the client, Lordship. The 3 phone numbers is given, all are switch off, Lordship. I have informed the local council.
Will
I
you
pray
do
for
that?
Monday.
All right, next week as prayed for.
item 21,
Pass over.
Item 22,
Item 20, your lordship, on behalf of Mr. Mohanty, kindly pass over.
Pass over.
item 23,
23.
Pass over.
Kindly pass over this matter.
All right, pass.
item 24,
All matters are being passed over today. All right, pass over.
item 25,
25. Pass over.
item 26,
Done.
item 27,
Day after tomorrow.
27.
My lord.
All right, let's just matter. No, not day after tomorrow. We'll take it up next
No,
week.
because of Mr. Joswant, senior advocate is appearing in this case, but that isn't available.
All right, let's just matter day after tomorrow. As per.
item 28,
My lord. The petition was initially appointed as Asa. And but she could not get appointment. For which the writ was filed. And in that writ, the Honorable directed that in portion 2 Annex 1, now Annex 1, but in the writ of Annex 13. So appointment will be completed. But violating that one, another notice was issued, which is Annex 5.
What was the order? Order was that
Present status.
no. You come to annexure 3,
My lord, that
29/1/2018.
May I be
Yes.
permitted, after going through the entire submissions, my lord, on the last occasion, your lordship directed to get the present status of that selection process, if any, whether any cause of action still survives or not.
Last order ta kaun dekhe?
That is on 26/7/2000.
Another lady got appointment, but by virtue of the face notification. So in that notification, this petitioner did not or did not file any for candidature.
So let us come to order dated. You had filed the earlier application 11922 of
My lord.
2013.
My lord,
Let us see the order.
that is Annex
Page 20. Please read.
Annex 3 at page 19.
Yes. Please read, sir.
So, considering the rival contentions of the parties, and as the court finds there is already a further advertisement at Annex 13, and the petitioner has also become a candidate pursuant to the said advertisement, nothing survives in the application as present to be decided, except directing the competent authority to conclude the selection process pursuant to Annex 13. Within 6 weeks. So this Annex 13,
So you were also an applicant pursuant to the new advertisement.
in that application, in that Annex 13, কিন্তু subsequently what happened, how did the order of the Honorable Court, a fresh notification was issued for appointment.
Yes.
And that is under challenge, which is Annex 5 minor.
Yes. So what is your instruction?
My
Last
lord,
order time.
instruction is, my lord, already, we have filed a counter, my lord, in this case.
Counter is not on record.
My lord, I think, my lord, that has been filed in March 2014, my lord.
Somehow it's not on record.
Huh?
Have you e-filed it?
No, that is since 2014, my lord.
Oh, 2014.
Yes, my lord.
Counter
No
is not
copy
on.
of service order.
No, भूल matter है नौजी नहीं तो
989.
9891 तो. There is no
98
counter here.
9891.
Sorry, my lord, this is a counter in
That is in the
the
other
previous case, my lord.
हाँ.
But here in this case, actually, I was directed to give the status of the status, my lord, and I have got this information that now another person has already been engaged and she is continuing in that particular post since 2018, my lord.
No, but the question is, if you look at Annex 3,
Yes.
issuance of a fresh advertisement is in direct violation of this court's order. Isn't it? Annex 3.
Yes, my lord.
Look at Annex 3. It says about the advertisement advertisement enclosed to the previous writ application as Annex 13,
Yes, ma'am.
which is obviously subsequent to the first application.
Yes, ma'am.
So Annex 13 appears to be the second application advertisement in which the petitioner was also an applicant.
Yes,
This court directed that you must conclude that, except directing the competent authority to conclude the selection process pursuant to Annex 13 within a period of 6 weeks. You cannot violate it.
No, that is the direction, my lord, in the year 2018.
Yes.
And my lord,
What happened to that selection? That is what I would like to know. Did you get the points?
Yes, madam.
Yes.
My lord, yes, madam. My lord, the information is like this, my lord. That the order from the CDM and PHO Kotak regarding selection of Asha in terms of the orders of the Honorable Court dated 29/1/2018, my lord. There are, my lord, the block nodal portion dated on 21st February 2018, my lord, he was authorized to go for the Asha selection, my lord. Then as for order date letter dated 19/5/2018, the selection of Asha, new Asha, my lord, that process was intimated, notified, my lord, on 22nd/5/2018. Then the meeting was held on 5/6/2018. And on the same day, Probina Mohanty was selected as per the merit list prepared by the member Asha Selection Committee. Communication of the CDM and PHO regarding that selection on 18/6/2018, the Asha selection guideline that has been followed, and till date, that Probina Mohanty is working in that particular position. My lord, that is that is not in the shape of an affidavit, but in shape of the chronologically, my lord, they have placed it and they have enclosed all the documents.
So now what are you challenging?
So that is, that is Annex 5, my lord. Annex 5 fresh application, as my lord and friends stated, that by virtue of the new application, this Probina Mohanty was selected. So I challenge that one because that notification is against the order on Annex 3.
You clarify this position by filing an affidavit.
I'll file an affidavit, my lord.
In course of hearing, it is brought to the notice of the court that by 29/1/2018, passed in WPC number 11/922 of 2013, a coordinate bench of this court disposed of the writ application directing the competent authority to conclude the selection process.
Yes.
Pursuant to the advertisement enclosed to the said writ application as Annex 13 within a period of 6 weeks. It is the grievance of the petitioner that despite such order, a fresh notification was issued. As per Annex 5 series. Learned State Council shall obtain specific instruction first as to whether the selection process was conducted in terms of the order passed by the coordinate bench in the previous writ application or writ application. Stop. A counter affidavit, an affidavit stating the relevant facts be also filed.
Yes.
List this matter on
4th September.
on 4th September.
Item number 29.
Correct.
Item number 30.
All right.
Item 31.
Correct.
Item number 32.
All right.
Item number 33.
Correct.
Item 34.
34, my lord. I'm for the petitioner, my friend is for opposite party. My lord,
34.
there is a interim report noting, my lord. It was sent to mediation.
Item 34.
TRP 24 of.
No.
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 It also 10014
Item number 35.
35.
I am for the opposite party.
You are for the opposite party. All right. Pass over.
Item number 36.
Item 36, sir, I am for the petitioner. The husband filed a CP under section 13(1) of Hindu Marriage Act and the Court of the Land Family Court Baleshwar. I am seeking transfer But at Varipada, there is another difficulty pending, your lordship.
The postal tracking report is inconclusive. Let press notice be issued to the opposite party by speed post, fixing a short returnable date. Requisites be filed by tomorrow. Peremptorily, place this matter on
4th September.
Hmm?
4th September.
4th September. Intimorder to consider.
Item 37.
May I please, your lordship? May I please, your lordship?
Yes.
My lords, this is a transfer application and I am for the wife, my lords. I am appearing for transfer of CP 188 from Nayagarh Court to Bhubaneswar, my lords. My lords, I myself and the opposite party, my lords, was my husband. Both of them are working in Bhubaneswar, Bhubaneswar, my lords. And second, my lords, I actually my father is no more, my lords, and my brother also is away. So it's getting difficult for me to travel. My lords.
Spending in Nayagarh, do you want it to be transferred to Bhubaneswar?
Yes, my lords.
Yes, what objection do you have?
It is a section 9 petition.
Hello?
Already, my lord, he has appeared and it is for conciliation. So, conciliation, your lordship may direct as your lordship.
Yes, what do you say?
And
My lord, that's true, my
Last
lord.
order.
He's appearing. But my lords, the conciliation is not going anywhere because he's not appearing, my lords. For the
I am
past
supplying the copy.
and in fact, in the last hearing, my lords, he has taken a leave.
Last order, my lord, 2014. Advocate for the respondent is absent. No step is taken, put over for conciliation.
Perhaps we have not been properly instructed. This order sheet shows that the petitioner was present, but you were absent. Anyway, let us not get into that.
Yes, my
Why
lords.
can't you agree for a mediation before the High Court Mediation Center?
Before the High Court, I agree, my lords.
High Court Mediation Center. Yes, what do you say? All right. Mediation, High Court, huh? Same order. Is this matter on 30th September? In the meantime, that mediation order will be there.
Yes, my lords.
All right. So the matter will come on 30th September.
30th September.
आइए जो stay कर दो. आइए. Huh? Oh, already stay. So
Yes, my
it is
lord.
not. Yes.
Much obliged.
Item 38.
I am the opposite party in this case.
I am for the petitioner in this case, my lord. Challenging my lord annexure 1, my lord. That is page 1, that is page 9, my lord. That the divorce petition filed by the husband. I am the wife. Husband filed the petition, but which is, my lord, pending before the Law and Family Judge Bhubaneswar, my lord. That transfer petition, I want to transfer that petition from Bhubaneswar to Barampur, my lord. Here, my lord, the case, my lord, annexure 1, the husband categorically stated in the cause title, my lord, the lordship kindly have a glance, page 10, his address and my address, my lord. His address Tilochana Sahu, the petition husband, whereas the address given at Dhenkanal, my lord. Dhenkanal, permanent address is Dhenkanal, my lord. My Taposini Naik, my lord, myself, my wife, my lord, here, my lord, Barampur, Ganjam, my lord. But his address, my lord, is permanent resident of Dhenkanal and working as a government employee at Dhenkanal. But he has filed intention to harass the petition at Bhubaneswar, my lord. Myself, my lord, working lady, my lord. But I have also a 8-year son, my lord, who will, my lord, after driven out by the husband, my lord. I am staying with my Barampur, my parent house, my lord. I having a 8-year son, and I am posted as Gajpati Parlakimundi, my lord, in the district of Parlakimundi. But he intentionally filed this petition to harass the petition the Bhubaneswar, my lord. He should have filed at better, my lord, at his own district, that is.
Yes.
My lord, before going through the argument of my learned friend, the jurisdiction should be here. That every petition under this act shall be presented to the district court within the local limits of whose ordinarily original civil jurisdiction. The marriage was solemnized. Your Honor, the marriage was solemnized at Bhubaneswar. I may kindly allow.
No. You are but unnecessarily taking the court to other matters. We are not on the jurisdiction point. You
No,
have a,
It
we,
cannot be transferred from the Bhubaneswar to jurisdiction.
so please listen to what the court is saying. Whatever, whether the jurisdiction the transferee court has or not is a different matter. This court has the power to proceeding from one court to another court.
Transfer, this court of matter cannot be transferred from Bhubaneswar to Ganjam. This is my
Cannot be transferred means?
because the hearing of the jurisdiction of the petition is Bhubaneswar court only,
All right.
not
All right.
because the marriage was solemnized at Bhubaneswar and both party of the were resulting last attended at Bhubaneswar.
All right. Heard counsel allowed, transfer allowed. Yes. Yes.
Item number 39.
Yes, Mr. Das.
This matter, my lord, has
Mediation report.
reached to mediation report. It has not yet been finalized. An interim report was there. Since
The report of the mediator indicates that the next date of mediation is fixed to 3rd of September. List this matter on 11th September.
Item number 40.
interim order.
Interim order to continue.
Item 40, one passover, my lord. I'm for the petition.
Yes, he's asking for a passover. All right, passover.
Item 41.
41 in Lordship, last day, Your Lordship asked me to take instructions as to whether this matter can be sent for mediation. I've received instruction that if it can, the mediation can be held in Sonpur, wherein the wife is currently based.
Who's appearing for the other side?
No,
he's not there.
Mr. Mahanti, he was appearing. In fact, it was his suggestion that the matter should go for mediation.
Well, he's not present here right now, so let us wait. Passover.
Lordship.
Item 42. Item 42.
42, yes.
That I'm the petitioner, Your Lordship. Seeking transport of the.
Anybody has appeared? Mr. R.K. Samantha Singh, advocate and somebody has appeared, but he's not appearing here. Jagabandhu Sahu, learned counsel for the petitioner is present. None appears for the opposite party. Raise this matter next week. Interim order to continue.
Item 43.
Lordship, as per your direction in this court, I have provided the extra copy to the council.
Yes, state.
Yeah, Lord, I will take the instruction. I do not have the.
Instruction aseni.
Nobody has.
Copy paichin to?
Copy up. Sir, lekha is one paiti. No, pale भी सब हुई कर दे. Help me next week.
All right. Let's this matter next week as requested by Learned State Council.
There is an interim order.
The status of service of notice on the opposite party be intimated, be informed to the court. Interim order to continue.
Item 44.
Wife application
for transfer.
Yes.
I am appearing for the opposite party. I have to take certain instruction and let it come 2 weeks after.
May I pray, my lord,
Yes.
send the file for conciliation.
This is the first time.
It is second day.
Sir, order okay?
First time admission notice.
After my appearance is for the first time.
No, the order sheet is not there. Second, the order sheet would have tag corner. How will you know?
Stand.
Very slow. List tanga not achi. Ke guru umko not achi.
List achi.
Yes.
Order here.
Can you stand? This is scanning. 3/7 फाइल फेराई ना तेरा फाइल फेराई नहीं स्कैन कहीं कि आज पचार तक डाकली स्कैन है जानियो केमती कोन हिच ऑर्डर टा पास हिच say yes you are saying something Mr. Mishra.
Lord, I am submitting that if conciliation will be made, because there is no chance of reunion. If there conciliation with the husband and wife in the mediation cell, matter will be ended.
What do you say?
Let it go.
High Court will-
Recording my counsel.
No, why? High Court mediation center?
Okay.
Mediation center order code. Release this matter on? I'm at the mediation center, you are? 1st October. In the meantime, that mediation order will be there.
Right. And the interim order, you
Interim-
will take adjournment.
All right, adjournment. Pass over text.
So item number 14. So item number 15.
Muslim rohi chala tumhe order ta pass kar. Thore asle jaate order pass kar na. This is a partner matter. None appears on repeated calls. Release this matter next week. Yes. Tapre item 15.
15.
15. Yes. Mr. Nath was there. In item 15. None appears for the petitioner on repeated calls. Release this matter by next week.
21st.
On 21st August. Yes.
So item number 16.
Or day after tomorrow, maybe adjourn.
Next week. Release this
So
matter
item
next
number
week.
17.
17. Yes, Mr. Now. Next week.
It is 21st. Next week.
21st.
So item number 21.
In the meantime, my lord, the number of affidavits have been filed by the referent persons, state, opposite party, 7, etc., my lord. I am to give a reply, my lord, a week time will be granted. I'll give a reply because many statements have been made that this was shifted, this was damaged, all these things. I found from the record, my lord, it's not correct. I'll give a reply.
All right. Already 2 months' time has been granted.
1 week time.
No, on 28th June. Anyway.
Yes, 28th June, I've seen it.
Sri J.K. Rothal Leonard Senior Counsel requests for an adjournment. As he wants to file a reply to the affidavits on record. Is this matter?
1st August.
21st August. 21st. 21st August.
21st August.
Yes. 21st August. The Porota Court.
28th August.
28th August.
Item number 22.
Got this. Adjourn karo.
Item number 23.
Adjourn karo date karo.
Item 23, I will file a date check over it.
You have filed.
I will file. One time. Matter relating to Appanonda for Anganwadi worker.
2013 matter, Mr. Hari. And you are asking for time on the ground that you will file a date chat.
I will just start and I will place the facts. I would transfer.
Right now.
Transfer.
Is this matter?
28th August.
28th August has paid for.
29.
Item number 24.
23. These cases of these petitioners, they are all ministerial staff under Culture University. What should we look at the convenience compilation that their prayer is for relaxing the provisions of law and regularization of their services. People Lordship will kindly see a convenience compilation I have given. Their respective dates of appointment is 2099, 2002. But they have spent the valuable period of their whole life here under the university.
Where is that compilation?
But it is convenience compilation I have filed along with the.
देख लो फाइल फिजिकल फाइल देख लो कन्वीनियंस कंपाइलेशन yes
But you may see at the first page itself their respective dates of engagement
yes
and the position they are holding I have given in the second one. 2099, 2002, 2099. So by this time, 24 years, 25 years, they have worked under the university without any interruption. They are working and discharging. But the Vice Chancellor recommended their case for regularization. At times, Vice Chancellor has recommended. But those recommendations I have filed along with my regent, my lord. The last recommendation is more recommendation. Annexure 14, page 21 of our regent document.
yes
See page 22. Since 2007, under such they have taken note of all the statement of facts which I have tried to raise. They have been engaged by the former Vice Chancellor through a selection committee, maintaining all recruitment formalities. Engagement of all the employees with consolidated salary have also been approved by the Board of Management from time to time. In the present scenario, the employees are continuing with batch of stay order passed by the High Court, which will not disengage the petitioner. These employees have been discharging their duties efficiently and attending all important academic activities like holding of convocation, undergraduate examination, seminar, confidential matter, including finance, all these 6 new PG departments with other existing PG departments. Besides, MOU with other institutions, 25 numbers of affiliated colleges are being managed by these employees with meager consolidated remuneration. They are working with all integrity and sincerity.
all right so this was a positive recommendation in your
recommendation.
Then what happened?
Now the government rejected it, saying that their engagement is not against a sanctioned vacancy.
Where is that
But that rejection, annexure 1, page 18, madam.
yes
Referring to Uma Devi, the government rejected it, my lord. Last paragraph se କହିଛନ୍ତି, since the petitioners were appointed on consolidated remuneration basis without prior approval of the government, without following due recruitment procedure as prescribed in Odisha rules 1991 for scheduled caste, scheduled ORV in violation of finance department, engagement being illegal and on pick and choose basis, as such their services cannot be regularized. This is the order. Number all these contingencies which they have stated to be violated, if my lords will see, there is a provision in that 91 rules itself with regard to relaxation. That is also covered by a judgment passed by the Honorable Court. My lords, say kindly see page 28. Page 28 of counter affidavit filed by opposite parties 1 and 2.
yes
States counter. Yeah.
what would be the annexure?
But this is in fact the entire 91 rules have been filed by the state. Annexure A by 1 starting from
all right
internal page 11. Annexure A by 1. The relevant provision is rule 34.
rule 34 yes
But let me see. Where it is considered by the Chancellor on recommendation of the Vice Chancellor that it is necessary or expedient to so to do in the interest of university and justice, he may by order relax any of the provisions of these rules in respect of any of the class of persons. But relying on this particular relaxation provision, in other university cases, this Honorable Court has judgment. That is at page, in my compilation I have given my along with my compilation.
no but what was the objection of the finance department? Let us see it again. They say that see, the petitioners were appointed on consolidated remuneration without prior approval of the government, without following due recruitment procedure and the ORV Act. So there are 3 things.
Right. The recruitment procedure, ORV Act, without prior approval of the government.
But the recommendation of the Vice Chancellor says something.
Yes, Vice Chancellor says they have been recruited following the process of law.
To a selection committee maintaining all recruitment formalities.
In any view of the matter, Lord, this would rely on the.
No, that is true. That is true.
Right.
But If the factual background itself is
Yes, yes.
wrong,
Mutually conflicting.
so
Mutually conflicting. If your lordship will see page 83 of
now
my
I'll ask the university, Mr. Mishra, what is your stand?
I have already filed my counter, my lord. So far as the facts of the case are concerned, that
No, I'm asking you a simple question. Please answer it.
my lord.
You have recommended
Yes,
very favorably, saying that they have been appointed through a selection committee following a due recruitment, maintaining all recruitment formalities. This is your
due
language.
procedure of law.
Yes, which means
Yes.
there must have been an advertisement, selection process and all that. Now the government has rejected it on the ground that no recruitment was followed.
Yes.
And secondly, ORV Act was not followed. ORV Act may not have been followed. I don't say so because your
In view of non-availability of the deputed class 3 post, with reference to letter number dated so 11/6/2000, and in order to ensure smooth functioning of the university, a number of non-teaching class 3 employees were temporarily engaged by the then Vice Chancellor of High Court University of Culture on consolidated remuneration. In absence of availability of such deputed staff from other department, continuing as such till date by the force of an interim order.
well, there seems to be some I think-
incongruity in the matter.
yes, yes.
But if your lordship see para 11 of their today's affidavit, counter affidavit.
You have filed an affidavit.
The university's affidavit. This affidavit, same affidavit they are referring to. Para 11.
Para 11.
There is kind you are opposite party?
They are opposite
Party
party
number
1 and 2.
3 and 4.
3 and 4.
3 and
If
4.
your lordship is not having that, can be seen from here also.
Yes, yes, we have. Yes,
What's
I accept it. No, no, we don't have.
8 and 11. Para 11 tab place.
What? Scanning what? ये देखिए आज दाखिल से लोगों CPC को declare किया. What is happening? This is by the university. No, still there is incongruity.
But
There is a factual dispute.
looking that, keeping that in view, if your lordship just see a judgment passed by this court, identical was the position, page 83 of my convenience compilation. Identical was the position there. This is the case of Utkal University.
Yes.
Identical was the situation there. This honorable court referring to Rule 34, directed the government to regularize after taking relaxation under Rule 34. Page 80. In this writ petition, we find that the petitioners were working since 1989 and they have already served more than 18 years on casual and ad hoc basis. Looking into the facts and circumstances and plight of the petitioners, we direct opinion number 3 to move the state government to obtain clearance to regularize the subject of the petitioner. If such a move is made, government in its Department of Finance directed to pass necessary orders directing to regularize services. But this identical was the situation here also. This is what has been done referring to Rule 34 of that 91 rules. The same rule also governs the petitioners. That is should be Rule 92, not 91, 92. So here again the Vice Chancellor has recommended for relaxation by a new press recommendation. That your lordship will find in the counter filed by the opinion number 3 and 4. The page 28 of their counter, the same counter which I just handed over. H by 3.
Page 28.
28. Para 30.
Page 28. Yes.
Sir,
it's
if recommendation which is 30/10/2018, then there is fresh recommendation is 9/5/2031. Declaration of
Yes.
19. Inviting a reference to the subject mentioned above, I am to inform you that 19 numbers of non-teaching employees were continuing their services temporarily since inception of the university 1999-2000. Out of these 19 non-teaching employees, 3 numbers so. 19 non-teaching employees were recruited following due recruitment procedure and interview conducted by the Vice Chancellor. The details of the interview conducted as per Annex 1 series. Subsequently, Government in Tourism so department, 24 numbers of temporary posts and 4 numbers of teaching posts were extended up to 28/2015.
all right, let me get it. So, action on this? The state has
No
to
action has been taken.
with the state.
That counter and other things, my lord, the copies have not been short of.
Same to
The same and down and.
A
the
counter
university-
ଦେଇଛି ନା copy file କରିଛି ନହେଲେ file କେମିତି ହବ counter ଟା file ହବନି.
University's counter is not available.
Anyway,
My lord,
you take instruction on this.
We'll take-
I'll keep it pending.
With respect to the subsequent recommendation, my lord, with
Yes,
respect
yes.
to the past
Because
recommendation,
you see, the language is very clear, very clear. These 19 numbers of non-teaching employees were recruited by following due recruitment procedure
But
and interview conducted by.
yes, but my lord, if your lordship will come to Annexure 1, page number 17, the impugn order in this case. There, my lord, the government has stated that what is the position of that recruitment, my lord. In the last para of the first page number 17.
What say pick and choose will କହିଛନ୍ତି.
Right.
Pick and choose will what I use କରିଛନ୍ତି.
Like, absolutely during all the rules, my lord.
There are two things. Pick and choose କଥା ସତ. Finance department जो କହିଲେ जो ये ସେ ବି ସତ. So all these where will these employees go now after rendering service for?
If at all, my lord, there is a question of relaxation, I think, my lord, the senior will agree with me. Who has the competence, not the government.
No, I think
No.
that rule says it's the chancellor.
Approval of government is necessary.
34. 34 is, I think,
Yes.
the chancellor.
Chancellor. And it is recommended to Chancellor also. Therefore, we implemented Chancellor as a party. Here is the summary report.
Who's appearing? Mr. Mishra?
No.
They are there.
Appearing.
Mr. Udgata usually appears to the chancellor.
I requested Mr. Udgata. He said, no, I will not be appearing.
No, probably he may not have been instructed.
But we took out no.
Um,
By orders.
Earlier, my lord, one letter will be issued by the register to appear on
shall
behalf
we
of
keep it pending or shall we direct
without vacancy.
since chancellor is a party, we'll direct the chancellor to consider the question of relaxation.
Chancellor, consequently government. If Chancellor
Chancellor
relaxes, then government will consider.
That will be the consequential order. So without entering into these factual aspects,
Let me direct that.
what do you say? Since in view of this 9/5/2024, this has been addressed to the commissioner, not to the chancellor. That is the problem.
Sir.
This 9/5/2014,
Right.
the latest recommendation of the vice chancellor is addressed to the government, not to the chancellor.
That should in fact be addressed to the
So
Chancellor.
all that this court can do is to direct the vice chancellor to make necessary recommendation in light of this
In the
to
right
the
of
chancellor,
this. Yes,
invoking rule 34.
yes,
Yes.
yes. If the Chancellor considers, Honorable Chancellor considers relaxation, then in the same order, government also be directed. Otherwise, there will be multiplicity of.
Obviously. Because there's no reason to keep it pending.
No, this may be disposed and the judgment passed by this court.
All right. The petitioners are non-teaching employees of the Utkal University of Culture, having been engaged since 1999-2000 in various posts.
Non-teaching post.
How non-teaching ta କହିଲି ପରା ଆଗ କହିଛି non-teaching ନା in various. Their grievance is that despite such long service, their services have not been regularized. Several letters recommending their case to the government for regularization are available on record. Ultimately, by order dated 3/5/2013, the government in Department of Tourism and Culture Department rejected the claim of the petitioners for regularization on the following ground. Inter alia on the following ground. Last pata, quote kar do, last paragraph of page 19. Quote kar do, since the petition was allowed. Sri P.K. Rathal, learned senior counsel, appearing with
Mr. A. Behera.
Sri A. Behera, learned counsel of the petitioners, submits that the vice chancellor, that the finding of the administrative department that the petitioners were not following due selection procedure is erroneous, in as much as the vice chancellor, while recommending the case of the petitioners for their regularization, has time and again reiterated that the petitioners were engaged following a due selection process. Attention of this court is drawn to a recent letter of the vice chancellor dated 9/5/2024 enclosed as annexure H/3 to the counter affidavit filed by the university.
I/3.
The latest.
Latest one. I/3.
I/3.
Sir, I/3? I/3. I तो number हुए नहीं अपना I किंतु कोले I/3 number हो चाहिए किले
Counter से
I O एवढा सब number हुए नहीं I/3 है ना H/3 कौन लिख ले
The last time the book is wrong. So consider April 9, 2024 enforcement and to the counter affidavit filed by
university wherein the following has been inter alia stated. Second paragraph ta quote करवा है ना कितने से लिख ले पर these 19 employees are continuing against sanctioned posts.
Yes.
That is very relevant.
Yes.
And we are reaching to a conclusion, well, there not, there is no sense.
So there is incongruity.
So that may be
So
considered.
obviously there is some discrepancy as regards the factual scenario. So be that as it may, this court also finds that Rule 34 of the Odisha University's Recruitment and Promotion of Non-Teaching Employees Rules 1991 provides for, confers power on the Chancellor to relax provisions of the rules where it is considered necessary or expedient to do so in the interest of the university and justice. Stop. Rule 34 is quoted here in the Therefore, even if there is some irregularity in the initial selection of the petitioners, it cannot, the fact lost sight of that the petitioners have rendered service for more than 2 decades by now, and that too apparently against sanctioned posts. This court has, in a plethora of judgments, held that where the employees are engaged against sanctions for long periods of time without long periods of time, a presumption arises that there is work available for them, and therefore there is a need to regularize their services. Moreover, as has already been stated, as has already been referred to herein before, the power of relaxation of the rules is available to be invoked by the Chancellor. Therefore, taking note of the fact that the petitioners have been rendering service to the establishment for more than 2 decades against sanctioned posts, it would be iniquitous and unjust to simply throw them out of employment on technicality. Rather, ends of justice would be met if the petitioners are considered for the services of the petitioners are considered for regularization by relaxing the relevant provisions of the relevant rules. Stop. This court finds that the Vice Chancellor has recommended the case of the petitioners favorably to the government. So, there is no such recommendation specifically to the Chancellor for relaxation of these rules. So, therefore, without keeping the writ petition pending, this court directs the Vice Chancellor of the university to make necessary recommendation to the Chancellor for relaxation of the relevant provisions of the 1991 rules as per Rule 34 of the said rules.
Yes.
If such a recommendation is made by the Vice Chancellor within 4 weeks, the Chancellor shall pass necessary orders within 4 weeks thereafter. So, in the event the Chancellor takes a positive view that the provisions should be relaxed, then necessary orders be passed directing the to move the government accordingly. Stop. The whole exercise should be completed within 4 months from the date of recommendation made by the Vice Chancellor.
Yes.
Till
the process completed, this status quo will continue.
Yes, yes. It goes without saying that till a final decision is taken in the matter, the petitioners shall be allowed to continue
Respective posts.
in their respective posts. Status quo. सीधा तो
That rule, my lord, that rules, as my lord and senior pointed out, it is not 1991, it is 1992.
I see this is 91.
No, but sir, ମୁଁ କହୁଛି ପ୍ରଥମେ ଲେଖା ହେଇଛି କିନ୍ତୁ ତା ପରେ page number 13, if your lordship will come to the page number 13 of our counter, the name of the nomenclature of the rule, my lord, that says, my lord, it is
92%. 91 duty ଲେଖା ହେଇଛି ନା ସେଟା ଭୁଲ ହେଇଛି sir.
Say 92.
ସେ ଗେଜେଟ୍ ରେ ଯାହା ଲେଖା ହେଇଥିବ ସେଟା ଠିକ ତ. So this is all. So let the recommendation.
Yes, yes.
Recommendation to relax. If the governor relaxes, end of the matter. Sanction post. Yes.
Item 25. Please, Lordship. I am appearing on behalf of Mr. Manthi, counsel for the petitioner. Whereas the case of the petition is similar to that of 24 item. They are on the similar footing. Only on the last occasion, notice were issued to opposite party 5 and 6, the finance department and the chancellor. The AD has not been received back as per the noting.
You are appearing, Mr. Mishra?
Yes, ma'am.
It appear করছো না এখন? He appearing?
Yes, ma'am.
এখন AD কোন হবে? Sri Anshuram Mishra submits that he has instruction. He shall also appear for the newly added opposite party.
Yes.
Yes. You want to file a counter or what?
My lord,
The same matter.
Take instruction in that matter. Whether
Similar matter, exactly similar.
two matters are
Exactly similar. See, coalition হবো.
Annexure 1, my lord, if your lordship will come to the impugned order. Annexure 1.
Same. No, same order.
same.
Same order. Same order করে দেওয়া তাহলে?
Hello.
Mr. Mishra?
Yes, ma'am.
But here, is there any recommendation by the Vice Chancellor?
No.
No. How similar kalkin tela? There, repeatedly, the Vice Chancellor, in that case, repeatedly, the Vice Chancellor has recommended. I read out those portions. I've quoted those portions.
Whether in the
Similar kin diju.
Take instruction to that.
Similar kali heile hijo. Similar covered matter. Eguda sobu ei quote চলেনি mo. Kore de bhalo ki dispose of koribe. Where there is a chance for the party to get the desired relief, not to come to the court again and again.
Another matter, WBC 14696, 2013. Deletion. He is not in the work.
He has a connected matter.
On the last date, your lordship had disposed of them.
So, all right, you take instruction, okay?
Yes, sir.
Learned counsel of the petitioner wants to
Yes.
take, wants to take some instructions from his client in this matter. Is this matter on 28th August? All right.
Published. Item 26, interim order to continue. Interim order to continue.
Into one. Okay.
26 item may be taken up next week.
Next week as prayer for.
So item number 29. 29 lots. One part. Urgent.
What adjournment? 2018 match.
Instruction lots.
When do you want?
Next week or 1 week after.
Date karo.
21st August.
21st. All right. Release this matter on 21st August as prayed for.
Okay. So item number 30.
30. Yes.
In the sub item, I am for the petitioner.
Yes.
Counter not filed by this lordship directed time and again.
Yes, counter.
Both the case counter is required.
There are two cases.
In
Two cases.
both the
One-
cases, my lord, from the CDP of Birmaraspur, my lord, we have received a parawise comment. In this matter may be taken up next week or 1 week after, my lord, we'll file.
Yes. So let them file counter.
Discussed with her, my lord.
Yes, ma'am.
Sri S.N. Patnaik learned AG submits that he has received the parawise comments
Yes, ma'am.
and requests some time to prepare the counters. Release this matter on
21st August.
21st August. If any be filed in the meantime. In both the cases.
Yes.
May
Or one.
Both the cases, my lord, I have received the parawise.
Copy of the counter may be short so that we can file rejoinder.
Yes, yes. The counter affidavit, if any be filed in the meantime after serving copy on the
Yes.
counsel for the petitioner. Yes.
may I submit one thing with permission. Item 22. I held up in the counter. I pray. It is short
Arjun is the
what a battle of motion descended and royal and lordship the predicament. Counter agenda so what?
କେବେ କହିଛି 28 ଆଉ ପଛୁଆ ଫେରିବେନି 28 କୁ ତ ହେଇଛି ଆଉ କଣ
I leave your lordship. But because ସେମାନେ descended କାନ୍ଥ ପଇଲା ପିଲା ମଲେ ସେ they are suffering. This your lordship has already.
you are ready
କେତେ number ଏଇଟା?
item 22
22 ରେ ସେ ବୋଧେ ଆପଣଙ୍କର।
item 22 is a connected matter
ହଁ
4 or 5 matters
ହଁ ଫୋରମାଟ ଯୋଉ ଦିଟା ଫାଇଲ ଦି ଜଣ ପରେ ତାଙ୍କର ଚ୍ୟାଲେଞ୍ଜ ଡିସିସନ ତାପରେ ରି ଆଡଭର୍ଟାଇଜମେଣ୍ଟ ସେଇଟା
already will take it up on 28 ତ କଣ 28 ଦିନ ସାରିଦବା ଆଗରୁ କେବେ ହବ 21
ଫାଇଲ
ସେଟା 21 କରିଦବୁ yes ତନ କୋଉଟା
So item number 31.
31 my lord. Lordship's order dated 5/7/2024. Lordship directed to take instruction to the London senior government counsel.
Yes, ma'am.
she was not granted any opportunity of hearing by the collector before passing Class 7 yes
My lord. In both the cases, my lord, I have got the instructions, my lord.
you are filing affidavit
No, my lord, only instructions.
all right
In the morning, my lord, I received it. Whether any opportunity has been given or not, my lord, that they have indicated that, my lord, opportunity has been given.
କୋଉଠି indicate
But, sir, if your lordship will come to the instruction with respect to WPC number 9991 of 2020. There are two instructions just now provided in two cases. With respect to WPC number, my lord, subject.
no opportunity of hearing by the collector the order was that she was not granted any opportunity of hearing by the collector
Well,
and you refer to annex para 7 of your counter
Yes, my lord.
which counter para 7 which I found to be inconclusive that is why I asked you to
My lord, this information that has been provided, my lord.
no you file an affidavit
Yes, ma'am.
you go through the governments and file an affidavit no
With
no file an affidavit
this may be taken into record, my lord. I will file separate affidavit.
no you take it and file an affidavit Sri S.N. Patnaik learned AG
Yes, my lord, I will done.
learned AG is ready with the written instructions but this court feels that the same should be incorporated in the form of an affidavit lest this matter
my lord,
On 21st August,
on to-
affidavit be filed in the meantime after serving copy.
yes.
Item 32.
I'm told my friend is tooth and nail acting bit time because why this is not, I am not doing.
No, I'm not. My lord, before your lordship starts, my lord, my learned senior starts, my lord. I'm just bringing my lord to your lordship's notice that there are two petitions which are before your lordship's board, which are completely interlinked. Reason being, my lord, he challenges the appellate order in the first one. I challenged in the second one his original appointment order, and my case was filed way back in 2016. It is pending for consideration, and after the appellate order has been passed, the quashing his selection, he has now challenged that appellate order. This is
And my lord, I will also bring your lordship's notice that I could not, in the certificate, I could not write that writ application number, which I have already filed an affidavit on 30th/7/2022 to correct my mistake. This court point out, and it was inadvertently.
All right.
So
That affidavit is on record.
yes, madam. I have filed an affidavit on 30th/7/2022.
Yes, it's on record. Yes, what is the matter? You are challenging the disengagement order and the Anganwadi appeal.
This appellate order.
Yes.
Appellate order is at page 15, annexure 4. In
Yes.
WPC number 16157 of 2022.
Yes.
Let me precisely, without wasting your lordship time, will give, my submission would be the last date of lordship can be turned to the rule first. That can be disposed of, and contrary affidavit has been filed by the state. In his case, they say everything is right, my appointment is correct. Filed a counter. State has a filed counter. In appeal, now they are filing a counter contrary to the counter filed by them in his case. This is the position. Be that as it may, the substantial question for lordship is, I will also bring to the notice of the counter the state, insofar his case is concerned. Lordship kindly turn to page 9.
Page 9.
Yes, ma'am. Where also the court let us fair to the court minimum.
This is the advertisement.
Page 9, annexure 1, advertisement.
Yes.
एतद्वारा पुरी सदर ब्लॉक पंचायत समिति तथा समन्वित विकास सेवा प्रकल्पर सर्वसाधारण अवगति निमंते जणाई दिया जाउछि कि एही प्रकल्प अधीन रे 35 गोटी अंगनवाड़ी केन्द्र अंगनवाड़ी कर्मी नियुक्ति निमंते योग्य प्रार्थीक ठारू दरखास्त आह्वान करा जाइछि। दरखास्त ग्रहणर शेष तारीख 4/2/2010 अटे। आवश्यक प्रमाण पत्र सत्यापित नकल सहित निज द्वारा संपूर्ण रूपे पूर्ण करा जाइतिबा निर्धारित फॉर्म धार्य समय मध्य जे कोनसी सरकारी कार्य दिवस रे व्यक्तिगत भाव रे रेजिस्ट्री डाक द्वारा पठाई परिबे। निर्धारित सीमा परे कोनसी दरखास्त ग्रहण किबा विचार को निया जीव नाही। देन योर लॉर्डशिप काइंडली टर्न टू पेज 10, सेकंड पैराग्राफ। ता 5/2/2010 लिख पूर्वाह्न 10 घटिका समय आवेदनकारिणी सेमाने दाखल करिथिबा प्रमाण पत्रर मूल नकल आनी निम्न स्वाक्षरित कार्यालय जांच लगाई नेबे। कार्यक्रम लागू चलिथिबा समय प्रार्थी धाड़ी रे आसीबे और निरवता करियो। लॉर्डशिप कैन टर्न टू लास्ट पार्ट। जांच समय ओरिजिनल प्रमाण पत्र जदि भविष्य में भूल प्रमाणित हुए से प्रार्थी दायी रही। नेक्स्ट मारा जांच समय मध्य जहाँ प्रमाण पत्र देथिबे ताहा केवल गृहीत होई परवर्ती नोटिस रे प्रकाश पाइबो। इज माय केस नाउ। जांच समय मध्य जहाँ प्रमाण पत्र देथिबे ताहा केवल गृहीत होई परवर्ती नोटिस रे प्रकाश जांच पर अन्य कौन से प्रमाण पत्र ग्रहण करा जीव नाही। दिस इज द ओनली क्वेश्चन फॉर बिफोर लॉर्डशिप। एडमिटेडली माय केस इज
on 4/2/2010, I had not submitted the photocopy of the residential certificate because no residential certificate was issued in my favor, though I applied before the Tahsildar because the residential certificate has to be within a period of 6 months. But on 5/2, I submitted the certificate when it was examined or verified by the authority. Therefore, I have secured the highest mark. I am a single caste candidate. It is undisputed that I have secured the highest mark insofar as the merit is concerned. So the question is now they are raising, since you have not given a copy of residential certificate on 4/2 and you have given it on 5 and another day because someone is disputing my certificate, then the Tahsildar asks for clarification, the authority asks the clarification from Tahsildar give it on 17/2, that yes, is correct. These are double things. Now they are saying, as if I have given the certificate on 17/2. In Lordship, kindly go to the counter affidavit filed by the state in the previous writ application filed by him. I will raise a substantial question also on this issue, whether the same authority can file two affidavit in a two-form manner. It is filed. Lordship, can you see their counter? Paragraph 2. The petitioner has filed the above caption writ petition.
You are reading from which?
I am reading from WPC number 3561 of 2006.
The connected one. Acha. 3561. Acha. Sitra counter.
There is a counter, state counter.
Okay. Counter update filed by opposite partner.
Yes.
Yes. Para 2. That the petitioner has filed the above caption writ petition praying for a
direction was the selection committee dated 4/2/2016 and consequential order of appointment dated such and the person. Then your Lordship can turn to page 2, paragraph A. On 21/1/2010, an advertisement was issued by the CDPO Puri Sadar inviting application from intending application for being engaged in Anganwadi worker for Hatadi Anganwadi Center. In response to said advertisement, 4 applicants had applied for being considered. The last date of application, submission of application was on 4/2/2010. The selection process was started. However, the selection process could not be completed and remained incomplete for several years. In the year 2013, after joining of a new CDPO, the matter was taken up and upon verification, it was found that all the records were not traceable in the office of the CDPO. Now they are saying 4/2/2010. It is admitted that till 2013, no action was taken. And accordingly, same was brought to the notice of superior officer. After consultation, it was decided, since the selection process is started, the file should be reconstituted and initiative should be taken to fill up the vacant post. Accordingly, all the applicants whose names are found in the registry maintained during that period were requested to file their applications once again in terms of the advertisement dated 21/10/2010. For reconstitution, they filed the acts. All the candidates who had applied pursuant to the advertisement of the year 2010 were requested to remain present on 11/2/2010 to 13/2/2015 with document as submitted earlier along with applications, reconstitution of record and verification of original certificates. Thereafter, meticulously going through the applications and the document file along with the said application, and after verification of original thereof, the selection committee invited objection against the respective parties. The present petitioner filed her objection against the opposite partner 5. Basing on her objection, a joint inquiry was conducted by the Tahsildar and the CDPO to ascertain this residential status of the opposite 5. That is the present petitioner in the previous case. Opposite partner 5. In the joint inquiry, it was found that opposition is a resident of this area in respect of the concerned Anganwadi Center. Being satisfied with the inquiry report and after taking into consideration the document, the opposite of 5 was selected as Anganwadi worker. Otherwise, enter as she had secured more marks than the other candidate, including the present petitioner. It may kindly be noted that the petitioner and the opposite 5 both are residents of service area. However, the opposite 5 having secured more marks then my lord, see, it is further submitted that the allegations made in the petition that the opposite party has filed their application 30 days after due date, and hence their application would not have been taken into consideration by the opposite party is incorrect. That they are saying on 17. That was an objection given by him thereafter the query was made. It is respectfully submitted that the opposite of 5 has submitted a result certificate on 5/2. That I also do admit. Fairly admit, because on 4/2, the date of giving the photocopies had not got given the result certificate. That is within the time stipulated. In terms of the what that judge somewhere original pore out which koi paribo nai. Has submitted the result certificate now that within the time stipulated. However, while issuing the certificate, they also has not mentioned the service area, which is Hattabandha and Hamlet, in which the Anganwadi center is situated. Thinking that the opposite party may reject your application since the result certificate does not satisfy the result, he once again approach the Tahsildar, who has basis on his array such as this, certified that there is on 17 to my lord. Then logically turn to the next page. If submitted that the technical objection raised by the petitioner is that the opposite party has filed an application beyond the date specified for filing of application, and therefore our application should not have been taken into consideration, is misconceived. For the reason that the certificate issued by the Tahsildar is on 5/2/2010, which is well within the time stipulated by the opposite party for verification of the application. So now the entire case comes. The consideration is, if I have not given on 4/2, these are the facts. And now in appellate authority say it is 17/2, which is incorrect, because they have admitted on 5/2 I have given, they have examined, it was in 2010, it was recorded in 2013, and I was allowed to continue till 2016, till the filing of the present date application. Meanwhile, Mr. Mahapatra's client filed a appeal against my appointment. He approached directly before the Hon'Ble court, saying therein that whether he has availed the remedies or not is not available on record. So Lordship has to consider only two things. One is, if 4/2 duplicate, to say photocopy is not available, on verification it is available, and I have secured the highest mark, and I'm a graduate, and they are plus 2 or something, that they have the status stated everything. Whether my candidature should be considered or not.
So we'll keep it to next week again. Heard in part?
Because I've been also in, sorry, my apologies.
No, Mr. Happens.
Why this is under challenge? Therefore, last 4 days we are there in the chief court salon. Each day it is continuing.
No.
That is the problem with me. Therefore, I'm seeking time.
No. Keep it as part of matter. We'll take it up next week so that you have completed. Now, Mr. Mahapatra and Mr. Mahanti have you are both also, you are the non-selected candidates. No. Originally.
Yes.
All right.
Yes, my lord. The similar nature of the cases, my lord. Those are filed, and few of the, I think, my lord, brother is also appearing in all those cases. I think, my lord, 3 to 4 number of cases of the same DO. So I have already discussed with them, my lord, and they have almost all prepared the counter in the other case, and they are going to adopt it, my lord. So this matter will be taken on 21st, my lord, so that before that, my lord, we will file the counter.
As requested by Sri Hasan Patnaik, Learned HDL, is this matter on 21st August?
Yes.
Counter will be filed in the meantime.
So right now 35. I think you can take an after launch. Mr. Mahapatra.
After launch, on a date ratio. Kelly.
Bye. So right now 40.
40.
I'm for the husband, opposite, but
yes.
Here in this case, the wife seeks for transfer from just family court Barampur to Bhubaneswar.
No, there was a connected matter to be listed along with this.
What happened in this case?
Last occasion, I submitted a TRPCRL has been filed to trustee and it was in defect. So when I verified, due to non-supply of certified copy, that registry rejected it. So I am taking step to file a new one.
What can be done now?
I will file a new one thereafter. 1 week time may be given.
Sri S.S. Mahathi, Learned Counsel for the petitioner, submits that the earlier case filed by his client seeking transfer of the domestic violence case pending before the learned SDGM Barampur has been dismissed for non-removal of defects and that he intends to file a fresh application. Stop. He seeks an adjournment for the above purpose. Release this matter
4th September.
on 4th September.
Interim order.
Interim order to control.
So right now 41.
May I please, Lords? Firstly, I am appearing on behalf of respondent. Lords.
Yes.
As per my instructions, is ready to go for conciliation. But she won't be able to travel to Bargad or Cuttack in person. If it can be done at Sonpur, because she is not getting any interim maintenance, nothing is there.
High Court Arbitration Center virtual mode.
Virtually, if High Court Arbitration Center.
Mediation center virtual can appear, but virtual, Mr. Mahathi, it will have no impact really.
Sonpur re gote dita date rahigala hejibo.
Sonpur dire apna kout rauchunti?
We are in Sonpur.
Bargad. Gotu Sonpur kete bata?
Bargad ru 80 km Lordship. Semane regularly astundi appear.
No, we are not able to come there. Earlier round of this Honorable Court directed that you can have it through the virtual mode. Thereafter, this virtual mode system is no longer possible. Pursuant to that, it has
why?
Because Lordship, when we at the time of examination of witnesses and deposition of witnesses, when you tried to produce some documents, we had shown it on the basis of that. Your Lordship, this is the second round of TRPC.
So document can there's a document visualizer.
He said a 9 that has been reflected in.
See the virtual hearing room. Say room everything is available.
Lordship, may kindly come to running page number 48.
No, I'll ask. Then if you say so, then I'll ask the court below to submit a report.
That is their observation, court's own observation.
Anyway, so now the question is where we can have that mediation. Let it be there in Sonpur.
Lots of
mediation mediation mein kar debo. Let the case records, let the records be placed before the secretary DLSA Sonpur, who shall appoint a mediator from the panel. The parties are directed to appear pursuant to notice received from the mediator and to render operation in the mediation proceeding. Let this matter on
1st October, sir.
1st October.
Lordship.
Is there any interim order?
Interim order is there.
Stay.
Lordship.
All right. Interim order to continue.
Gratefully, Lordship.
I don't know 45.
Mr. Bahadur. My lord, your lordship was pleased with the petitioner on bail, subject to condition of 20,000 cash surety, and one of the solvent surety must be a blood relation. My lord.
Normally, I don't pass such order. How?
My lord.
Oh, he does not belong to the state of Odisha.
My lord.
So?
My lord, lordship was passed on 13/7/2022. Bail order. Till date, he was unable to furnish the bail bond and cash surety value.
Why? What is the difficulty?
Difficulty is no blood relative has recorded ROR in his name. And 20,000 poor man, 20,000 unable to arrange the 20,000, my lord.
Local security for the but that cash security will be there.
Some relief may be given.
No. The prayer for modification has been made on the ground that no close relation of the petitioner has any landed property to be kept as surety. As such, despite being granted bail since 13/7/2022, the petitioner is still languishing in custody. Having regard to the above, having regard to the date of passing of the order, this court observes that it has almost amounted to refusal of bail, which this court never intended. As such, said order is modified only to the extent that the court below shall insist upon 2. local solvent sureties belonging to the district of Balashore. All other conditions shall remain intact. Yes. Item number 46.
46, may I please, your lordship? My lords, the offences are under section 307 and 302 and other allied offences. That's total charge sheeted witnesses are. My lords, total there are 20.
Yes, go on.
My lords, out of total 21 charge sheeted witnesses, 12 are examined.
This is
by
a dispose
now.
of case.
Pardon, my lords.
Where is the surrender certificate?
My lords, we weren't apprised properly by the
Let's see.
petitioners actually.
Let's
So
see.
I was praying if my lords could
Okay.
call for a report from the court in session.
What is the name of your client?
It's Ajit Jena.
Ajit Jain. Oh, he has surrendered. All right. No, he did not surrender. Therefore, NBW has been issued.
Yes, my lords, the petitioner has not instructed us in a proper manner. So I was praying if your lordship could call for a report from the
No,
court.
he report eighty hello. Hello. Order dated 27/10/2023 of the court below indicates that the petitioner has not surrendered to custody despite expiry of the period of interim bail, for which non-bailable warrant of arrest has been issued against him. Stop. Since the petitioners have violated the order passed by this court, the bail stands rejected. The court below is directed to issue necessary orders for early execution of the NBW.
Item number 47.
Your Lordship, in item 47 is a CBI matter, Your Lordship. Earlier, herein the petitioner earlier was released on interim bail, Your Lordship. Now he has surrendered, Your Lordship. He has again filed. Yes, Your
This
Lordship.
is when Justice Mahapatra's order.
Your Lordship had granted interim bail.
No,
but-
just let me just know. Let me
Yes.
just find out what has happened in this case.
Yes, Your Lordship.
On verification of the detectives, no fresh applications for seeking terms in the order which is sought to be extended has been passed by 11th court bench. So the matter has come, therefore it has come to me,
Yes, Your Lordship. Yes.
being directed by the Chief Justice.
Yes, Your
So
Lordship.
what happened, Mr. Pradhan?
Yes.
You have surrendered.
Yes, my lord has granted interim bail for a period of 4 months for heart surgery.
For heart surgery,
For
yes.
heart surgery. The petitioner could not able to arrange the funds. I have given the estimate. As well as, my lord, other parameters are not stable. So, my lord, it was there. I filed an extension application. My extension application was listed before the Honorable Court on 22/7/2024.
Before this batch?
No.
Before Justice Mahapatra?
On that date, my lord, this Honorable Court has held some other bench. So let it be placed before the Honorable Chief Justice for assignment. But that date was my date of surrender.
Okay, so you surrendered. Okay.
Otherwise, my warrant will be issued.
So then, Mr. Pradhan, you will have to file a fresh application.
Fresh application will come. That is flag U.
Like?
Flag U.
Yes, Your Lordship.
Yes.
Yes,
Yes, what do you
Yes, Your
say?
Lordship. A fresh IA has been filed, Your Lordship. We'll seek instructions in the matter. Your Lordship may kindly provide 1 week time, Your Lordship.
1 week time? No, go for it.
All that.
CBI matter.
Absolutely. Because at least for health condition is not stable. That I can.
No, considering that I had granted.
Yes, correct, madam. Team was constituted, they have not suggested for that.
Yes.
This is not got a constituted team.
Sri Pradhan, Learned Counsel for the petitioner submits that his client surrendered to custody without undergoing surgery for various reasons. Presently, the present application has been filed seeking interim bail as for the same reason. For the same reason, that is cardiac surgery. Learned Counsel appearing for the CBI requests sought adjournment to take instructions.
Yes, Your Lordship.
Is this matter 21 तारीख, 21st August? What a week time देंगे? Only 1 week time.
I'm
Yes.
much obliged, Your Lordship.
Obtain instructions.
Yes, Your Lordship.
Positively, yes.
Okay,
Item
Lordship.
48.
Item 48. The order be corrected accordingly.
Item 49. 49 may please. Bill and IA for a modification in the order dated my lord 11-10-2023.
This is CMAPL.
Well,
Item 49 though? Oh, sorry.
49
ABL. Yes.
Here my lord, I am praying only for parity. My lord.
Parity?
First step, second step order was passed. Me.
Yes, what do you say? Now, considering the submissions, the prayer for modification is allowed. Stop. It is directed to the extent of adding the following sentence at the end of paragraph 5 in order dated such and such. Further, the courts below shall also extend the principle of parity, since it is submitted that some co-accused persons have already. Item 50, CMAPL. CMAPL?
A transfer application was dismissed, my lord. Dismissed. I list the
notice
my lord.
Notice transfer application.
Transfer application notice se appear karnathala.
Tell it notice jivo.
Notice jivo.
Issue notice to the opposite party by speed post, fixing a short returnable date. The requisites be filed by tomorrow peremptorily. Peremptory order.
Peremptory order.
Tomorrow peremptorily. List this matter on
4th September.
4th September.
Item 51. Which gives custody since 19/9/2021. Lordship.
Very good.
Lordship for alleged offence under section 20B, 2C and 27 of the NDPS Act.
Very heinous offence.
Lordship, he was released on interim bail for a period of 3 months, Lordship.
Wrong order.
And meanwhile, he has surrendered in time, Lordship.
Very correct.
Lordship, meanwhile, the trial has not commenced till now. Last witness was examined on 23rd April 2023. Out of 11 witnesses, only 8 have been examined. Since
8 witnesses have been examined. Then you are lucky, Mr. Manti. You are lucky.
Lordship, only after.
I can tell you from my own experience as a special judge, I am dealing with NDPS matters. It is very difficult.
Yes, sir, Lordship.
Very difficult. The witnesses, long depositions, marking of exhibits and all that. It takes time.
Yes, sir, Lordship.
Almost over.
Last witness was examined on 2023, Lordship. In the order sheet, it has been categorically.
You were granted interim bail?
Yes, sir, Lordship. Lordship, that is at annexure, page 57, Lordship.
19/9/2021. In such and such case. Sri Abbas Manti, learned counsel for the petitioner, submits that the petitioner that trial has been progressing very slowly, in as much as only 8 witnesses.
8 witnesses out of 11 witnesses.
Only 8 out of 11 charge sheet witnesses have been examined so far. The last witness was examined on
April 2023, Lordship.
In April 2023. Stop. He further submits that because of such long detention in custody, several domestic problems set up in the family, in his family, which require urgent personal attention of the petitioner. He therefore requests that the petitioner may at least be released on interim bail. Stop. Learned State Council opposes the prayer for bail by submitting that huge quantity of contraband was seized. Stop. Considering the submissions and taking note of the apparent delay, apparent delay in trial, this court is willing to take a lenient view. Let the petitioner be released on interim bail for a period of 2 months. Such and such. Further, the court below is directed to submit a status report regarding the trial, regarding the progress of trial. List this matter on. List the main bail application for hearing on. মাসে 2 মাস পরে করো। হ্যাঁ?
October 21st October.
21st October. Yes.
Published. Item number 52.
20B2C, your lordship. Similar putting co-accused persons were granted bail by your lordship. Page 49.
Yes?
Page 49, your lordship. Vikas Bhatt and the present petitioner, the two persons were inside the car, your lordship.
Yes.
Yes, my lord, similar footing.
Same.
Because
Same order.
was also
Same
there,
order.
including the present.
Item number 53, may I please? This is the third bail application. This is 20B2C, my lord.
राजीव कुमार महतो, ये कौन बाहर लोगों की?
Yes, Jharkhand.
8/7/2021. Till that, my lord, the trial has not commenced. C report submitted in the month of May.
The court below is directed to submit a report regarding status of the trial. Is this matter on?
And another instruction your lordship may call for that one person who accused Raman Kumar Raut has been granted interim coordinate bench. Now he is regularly appearing as per my instruction, though he is belongs to the outside of
Local area, but
outsides.
Raut will call.
Raut, but he is an outsider.
Further,
Raut, RAWT.
further, the court below is directed to intimate whether the co-accused who was granted interim bail by a coordinate bench of this court is appearing before the court below regularly or not. List this matter on
4th September.
4th September.
Item 54.
Ekdam short date is. Ekdam short date is. Item 54. 54, yes.
My lord, I am appearing for the informant. Last date, the petitioner was also absent. After obtaining the interim order, remaining absent grievous injury.
Second application, there was a direction to surrender. It has not been complied.
So let us ask the court below to intimate what has happened, whether he is surrendered or not.
Anticipatory bail, my lord.
Oh, anticipatory bail. That's it.
Second application.
First application was
First
rejected.
second within 2 weeks. Direction by. Not complied. Again, he has filed.
Will dismiss it? None appears on repeated calls. None appears for the petitioner on repeated calls. Sri P.S. Naik, learned CGC? No.
No, this is private informant.
Sri P.S. Naik, learned counsel for the informant is present. Since there is no appearance.
Previous date.
And since there is no appearance, since the petitioner had also not appeared on the previous occasion, it is presumed that he is no longer interested to pursue the bail application, which is therefore dismissed for non-prosecution.
Interim order is there?
Is it automatic?
Item 55.
Item 55, the mother-in-law was granted liberty, but in the meantime, she was arrested and taken to custody. Item 55.
55 is infractions, dismissed as infractions.
56 customer is a sister-in-law that having 2 years of a female child, breastfeeding child, and
let's see the affair.
Yes, correct.
Earlier on merit, it was rejected.
There is no allegation, just submit. There's only based allegation they're demanding dowry. No, subsequently the husband was arrested, case was found to 306 to 04B.
First or second or
I can see the report of the IM, the main accused arrested. Only because
protect you, let him obtain the case diary.
Only because of the paneer in the house, the quarrel ensued, and the deceased committed suicide.
Mr. Rauta, once I have rejected it. Rightly or wrongly I have rejected. Second application is not material. This is not a regular application. This is an anticipatory application.
Yes, my lord. Now the turn to case 306, not 300. So arrested, 306 turn.
You obtain the case diary. The case diary be obtained. Place this matter on
28th August.
28th August. No course of action. ସେତିକି relief ଆଉ।
Actually ଘରେ ଛୋଟ
ଯେତିକି ପାଇଲେ ଆଉ।
ଛୋଟ ଘଟଣା ପାଇଁ ସେ committed suicide.
ଯେତିକି ପାଇଲେ ମିଷ୍ଟର ରାଉତରାୟ ଆଉ କଣ କରିବା?
Husband now in custody. Now the sister-in-law is married, my lord. Staying separately.
ये भी
Having separate mess, my lord. And no allegation, my lord. Father-in-law my lord, took some money to the house, my lord. The quarrel between my incident between the father-in-law, my lord.
ଗୋଟେ ମଣିଷର ଜୀବନ ଯାଇଛି ପରା।
ସେ ସୁଇସାଇଡ୍ କଲା ଆଜ୍ଞା। କେସ ସୁଇସାଇଡ୍ ହ୍ୟାଙ୍ଗିଂ ମିଲଟ୍।
କାହିଁ ଯଦି ସେ ଭଲ ଚଳୁଥିବ କାହିଁ ସୁଇସାଇଡ୍ କରିବ? ଖୁସିରେ ଲୋକ ସୁଇସାଇଡ୍ କରନ୍ତି କି?
କୌଣସି ସ୍ପେସିଫିକ୍
ଖୁସିରେ ଥାଏ ସେ ଯେ ମୁଁ ଆଜି ଖୁସି ଅଛି ମୁଁ ଯିବି ସୁଇସାଇଡ୍ କରିବି। ଏମିତି କିଏ କହିବ ମିଷ୍ଟର?
ସଡନ୍ ମିଲଟ୍ ସେ କମ୍ପ୍ଲିଟ୍ ସୁଇସାଇଡ୍ ମିଲଟ୍।
ମାନେ ଏତେ ଖୁସିରେ ସେ ସୁଇସାଇଡ୍ କରିଦେଲା।
ସେ କହିଲା ତୁ ମାକୁ ଭୁଲ ମାଗ ନହେଲେ ତୁ ଘର ଛାଡି ପଳା। ଦିସ୍ ଇଜ ଆଲିଗେସନ ମିଲଟ୍।
କରିବେ no course of action relief ପାଇଲେ ଆଉ। You can't say that you have not got relief. You have got relief.
Yes, then
2 ମାସ ଭିତରେ ସେ ଜଣେ ସୁସାଇଡ୍ କରିଦବ ବାହାରେ।
ଥିବ
intuition ମିଲଟ୍।
ଦେଖ ୱିକଲି ଟିକେ ନବା ଟାଇମ୍ ଅଛି।
Fixed.
এটা কেবে 28th August. Yes, Mr. Rautray, 28th August. Weekly list.
List item number 33, September 1st week of
हाँ कर दो ना September 1st week कर दे। पास और सॉरी लगा सो।
नहीं weekly के पास।
Weekly के पास और चला हाँ weekly के पास और
September 4
लगी दो ना। Weekly के पास और लगी।
29 ते पास और
कोटा 29.
29.
Which is that matter?
Yeah, other matter. Yesterday ଗୋଟେ interim
interim application ଆସିଛି। ये admission पे ଅଛି ତ?
admission.
Admit ହବ interim application. We'll take it up. ତାପରେ ଯିବା 33 को।
No course of action till then.
लिखी परा।
ଡାକିଲେ କଣ
ମୁଁ ଦେଇଛି ଅର୍ଡର ମୁଁ ବି ଲେଖି ସାର୍।
ଭାରି ଡର ଆପଣଙ୍କର ନା? Yes, Mr. Satpathy,
may I please respond? The plaintiff has against the reversing judgment, my lord. The plaintiff filed the suit for declaration right title interest and confirmation of possession with a prayer for recovery possession against the state. The plaintiff filed the suit for declaration of right title interest and alternative prayer of recovery possession if found to be disposed during pendency of the suit and for consider relief of permanent injunction. The plaintiff's claim before the trial court is that the settlement ROR has been prepared wrong and he could not stay to correct the ROR in time, and the basis of the title of the plaintiff is he has purchased the land from Bhagirathi Mishra, who got the land from the original owner Jagannath Kara through on the basis of unregistered lease in the year 1945.
Hatpota.
No,
ଅମଲ ନାମା ପଟା। ଏଟା ବାଲେଶ୍ୱର କି? ଏଟା ବାଲେଶ୍ୱର ଏରିଆ?
ଭଦ୍ରକ
ତାହେଲେ ଅମଲ ନାମା ପଟା। It is known as ଅମଲ ନାମା ପଟା।
ଖାଲି ଲେଖା ଅଛି ଲିଜ୍ ପଟା। ହାତ ପଟା। Same nature same unregistered lease. There on the basis of such unregistered lease deed, tenant ledger has been opened in his name. Rent has been accepted by the state. And the present petitioner, the plaintiff, is in possession of the land.
The suit was decreed.
Suit was decreed. And the possession has been confirmed by this trial court on the basis of admission by the state authorities. Councillor had made an inquiry in a proceeding and the inquiry found that the plaintiff is in possession.
Now, why did the trial court, appellate court reverse it?
Reverse it, saying that since the MSROR has been prepared as the Gramya Jungle, this is a communal nature and it cannot be exclusive possession of the land. যেহেতু ଏବେ ଭଦ୍ରକରେ ଚାଲିଛି
Sri P.K. Satpathy, counsel for the appellant, peruse the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. No. 2 and 3.
Mandate.
Huh? 2 and 3 will do.
One mandate. One time she contains
1, 2 and 3.
1, 2 and
6 of page number 6 of 7. Issue notice. State, I think, can accept. Yes, Mr. Das. I think you can appear for respondent number 1, Collector Bhadrak.
Yes, collector.
Sri A.R. Das Leonard AG accepts notice for respondent number 1. Let appeal memo be served upon him within 3 working days. Issue notice to respondent numbers 2 and 3. The pro forma also we will issue.
Notice नहीं जाएगा।
Okay. नहीं जानते।
तो order 1 rule
No, नहीं जानते, नहीं जानते। कौन लिखा है? The notice to the by registered post with AD, returnable within 4 weeks. Requisites be filed within 3. There is limitation? No.
9.
Within 3 working days. Call for the LCR. Place this matter on.
7th October.
आता पर को ना नवंबर को ना हाँ 6th November आइए 894 of 2024 notice as above accept one set of process fee in the interim it is directed that status quo with regard to the suit land shall be maintained till the next date.
Okay.
Item 54 non-appraisal disposal after launch नहीं दौड़ी
दौड़ी के आसुले ठीक है किंतु कौन करेगा
नॉन आफ्टर लॉन्च नहीं
ताले ताको नेक्स्ट वीक कर दे नॉन डिसमिसल टा कर दे काली कर दे काली कर दे
काली कर दो मैडम
काली कर
इंटीमेटर कंटिन्यू
ହେଲା item केते सेटा 54 Mr. Naik is there on the other side. Please inform Mr. Naik.
My lord, I will inform.
Mr. Parsasarthi Naik.
Parsasarthi, I will inform.
Inform. जान तो अपन जान तो बोलो कल ऐसे it will come tomorrow.
Item 18, your lordship is stick to today.
Yeah, I will take it up. I will take it up. Lucky done. Item 18 lucky done.
Item number 18.
Again.
Your objection?
My.
Yeah.
Objection for अच्छी है हमारा ऐसे.
My. Lister.
नहीं objection तो कहीं नहीं. अच्छी. Yes.
My.
Here, my lord, 2 applications have been filed by the state. One is seeking permission to appeal against the judgment passed in appeal. And the other is to condone the delay. Here, what has happened, the suit was filed without impleading the state as a party, which the trial court found that it being recorded in the name of the state and state having not been impleaded as a party in the necessary party, it suit dismissed. Appellate court, under a misconception, since the OSFC is a state government undertaking, non-impleadment of state doesn't become fatal. That is how the appeal was allowed and the plaintiff suit was decreed. Now, state when came to learn about such a decree on a mutation application having been filed, the present 2 applications have been filed after the process was completed through the formalities. So my learned friend has objected to the two grounds. Since the state was not a party, it could not have come up in second appeal. And the second is about the delay. In both the IA, he has filed his objection, stating that there has been huge delay and it has not been explained.
Yes.
My submission would be, your lordship will kindly find the non-trial court findings.
Anyway, this is the matter, okay?
Yes.
Suit was dismissed for non-gender of parties.
Yes.
So that is the matter of the property is recorded in the name of the state.
Yes,
So why is OSFC a party? It was a
This was something like borrowing from the OSFC. It was subsequently auctioned. Your trial court has specifically found.
no. Was the property mortgaged?
Yes.
How could it have been mortgaged when it is recorded in the name of the state?
That is the enigmatic part of it.
Yes, Mr. Mishra.
I'll explain. But the aspects, I humbly beg to assist. But my license should not connect the merit with the limitation because
that is. I just wanted to understand.
ମୁଁ କାହିଁକି ମୁଁ ଆସିବି ସେଇଟା ବି ମୁଁ answer କରିବି ସେ merit ଟା. There are 2 applications. One for grant of leave to appeal
the other for limitation. My humble submission would be
Only if leave to grant is, leave to appeal is granted, then only the delay will come.
Yes.
Isn't it?
my lord, no, my
There
lord, I
There
will
are two stages now.
my lord, in that event, the appeal gets my lord, into picture. My humble submission would be after the delay is gone, the appeal will be considered.
All right.
But I humbly beg to submit. My lord, in fact, I was having little also doubt about that whether this application or that application, and I had a my lord, subject to what your lordship will decide, consultation with some of the senior colleagues, where I found that the limitation application is to be considered first in this sense for the reason, because if the leave is granted, then obviously the limitation application gets obliterated.
All right.
So therefore,
Fair argument.
one more thing I beg to humbly point out to your lordship, this I am not escaping from answering the question whether on merit he should be granted leave or not. That I filed an objection, I will answer that. But there cannot be, in my humble submission, a simultaneous consideration of both the application.
No,
if he gets over the limitation, then question of grant of leave.
You submit on limitation.
Then also I will also only little bit assist on the merit thereafter, for the reason my learned senior has addressed on merit also, creating a doubt in your lordship's mind that as to why the state was not made a party. But so far as the limitation application is concerned, I beg to draw my lord's kind attention to that petition. Your lordship will see that is IA 425 of 2020.
Yes.
The lordship will find the impugned judgment was delivered on 2016, page 2, paragraph 2.
Yes.
Now, mutation case was initiated in 2016, paragraph 3, your lordship. Now, they get but immediately after the receipt of the mutation application, the collector made a query and instruction was issued. So there is a gap from 2016. I am pointing out this vis-a-vis the adjudication also made in the contextually in the same kind of material by the Hon'Ble Apex Court also. Therefore, I will assist. Why I am pointing out this is because of that. Then 2019 only they get the certified copy for 5. From 2016 to 2019, nothing is mentioned in detail. This I am submitting vis-a-vis also the ratio laid down. Then, my lord, what has happened? Your lordship will see 2019, the copy was received. Then, your lordship will see paragraph 8. Paragraph 8, State Council 11/12/2019 रे कहिले जे relevant document धरी आसन case file करिया पाए. Then again 5/8/2020 it was filed. Here also there is a gap of almost 10 months. 7 months. 7-8 months. This 16, this apart from the other things has not been explained with material particulars. This is what I beg to submit. Now, this aspect of the matter, so far the state is concerned, and your lordship knows now it has been held that state cannot be treated in different parameters, they have to be treated in the same parameter. Now, the Hon'Ble Apex Court had the occasion to deal with this limitation aspect by the state in the case of Postmaster General, my lord, and others, reported in 2012 3 SCC page 563.
Off-quoted judgment.
That has been referred to by this Hon'Ble Court also. I will cite that authority on the point.
Off-quoted judgment.
Therein, interestingly, I may be pardoned, my lord, by the time I inquired, I committed a mistake. I should have inquired from the beginning from my associate. They have not made a copy. Doesn't matter. I apologize for that, my lord. That should have been a copy in place for your lordship and for my land senior appearing for the state. Here in paragraph 20, your lordship, in a tabular form, notes the dates where it has been mentioned from 2009, 2010, many dates. Pursuant to the direction of the Hon'Ble Apex Court, they filed a supplementary affidavit. Then gave these dates, which are almost nearer to each other. Unlike in the present case where it is 3 gap, your lordship has in 16 to 19, then another 8 months gap there, my lord, no explanation, and in between also no explanation. Despite considering this explanation which has been quoted in paragraph 20 in a tabular form, from page 26, 27, 28, 29, 30, these are small paragraphs. May I place it?
No, you just tell me the gist.
The gist is this. I'll place that gist only. Another opportunity was given to file the details. That thereafter, though we are conscious of the fact that in a matter of condonation of delay, when there is no gross negligence or deliberate inaction or lack of bona fide, a liberal constitution has to be adopted to advance substantial justice. We are of the view that in the facts and circumstances, the document cannot take advantage of various earlier decisions. The claim on account of impersonal machinery and the bureaucracy methodology of making several notes cannot be accepted in view of the modern technologies being used and available. The law of limitation undoubtedly binds everybody, including the government. In our view, it is the right time to inform all the government bodies, their agencies and instrumentalities that unless they have reasonable and acceptable explanation for the delay and there was bona fide effort, there is no need to accept the usual explanation that the file was kept pending for several months, years due to considerable degree of procedure, the red tape in the process. The government departments are under special obligation to ensure that they perform their duties with due diligence and commitment. Condonation of delay is an exception and should not be used as an anticipated benefit for the government departments. I pause here for a moment. He says because we have a right, that right hasn't taken away. I'll explain that. So anticipated benefit, they want a condonation also. The law shelters everyone under the same light and should not be swelled for the benefit of a few. Considering the fact that there was no proper explanation offered by the department for the delay, mentioning various dates, according to us, the department has miserably failed to give us any acceptable and cogent sufficient reason to condone such a huge delay. My land senior also employed the word huge delay. Accordingly, the appeals are liable to be dismissed on the ground of delay. I'll file this authority matter to assist your lordship. Here, number of dates were mentioned. Here, lordship has seen the gap in dates also. No explanation, nothing. Even from 16 to 19, how the file moved and what happened, nothing is there. Now, my lord, my submission is the delay application is, and thereafter only the leave to application will come. If your lordship decides the delay application in favor of the state government, I'll just assist little bit since my land senior has addressed on the question. But so far as leave to appeal application is concerned, he cannot depend on the finding that is there in the either trial court judgment or appellate court judgment to say that I have a right to leave to appeal. The right has to be demonstrated by virtue of some material to show how the right is affected. If your lordship will kindly peruse the petition that has been filed, I'll also demonstrate from court and appellate court judgment that he has no right to participate. Leaving aside that aspect of the matter, the leave to application, leave to file application that is IA 424 of 2020 also lacks any material particular except reference to the judgment as to how the state is prejudiced. Now I'll come to there is nothing, your lordship will see. But that right has to be demonstrated for seeking leave to appeal. It is not a blanket petition just filing and saying trial court judgment in my favor and appellate court is against me. So therefore this is a reversing judgment, I should be entertained. It is not that way. So far as leave to appeal is concerned, you have to demonstrate your right for a leave. Where you are not a party to the proceeding, how you are prejudiced. Now your lordship will see how they have been prejudiced. They have in fact taken no steps. What has happened? The suit was filed by me. When I purchased the property from OSFC by virtue of an auction, because the person that is Prasanna Kumar Naik, who had mortgaged the property, which was recorded in his name, I the property to the OSFC. Because of default, the property was put to auction. So therefore, I filed since after auction also, the benefit of the auction was not given to me, I filed the suit for declaration. So the cause of action, so far as the suit is concerned contextually, is nothing to do with the state government. This is what I beg to submit. Because my entire cause of action was vis-a-vis this OSFC, because OSFC put it to auction. Now, I'll show you.
You said that the property stood recorded in your name, which you mortgaged with the OSFC.
No. Property stood recorded in the name of Prasanna Kumar Naik, who mortgaged.
Prasanna Kumar Naik.
It was put to auction.
So here there is a factual dispute because Mr. Das probably said that the property is recorded in the name of the state.
That is the fact.
That I'll show to your lordship, my lord. That I'll show to your lordship. I am not running away from that also. That I'll show to your lordship, my lord. What I humbly beg to submit, even if assuming the property was earlier recorded pre facto, being recorded in the name of Prasanna Kumar Naik in the name of state government. They have nowhere, they have their own machineries and forums. They have nowhere taken steps to rectify this recording in favor of Prasanna Kumar Naik. That stood good at the time of mortgage, that stood good at the time of auction, that stood good when I purchased post facto the auction. So therefore, to say that earlier it was in the name of the state file or right to be implemented as a party, that is what the appellate court has dealt with. I will point out that. So here, my relief was purely against the OSFC who had put the property to auction. So I had nothing to, because your lordship will contextually appreciate the cause of action and the basis of the case. The basis of the case was nothing to do with the state government. The OSFC put the property to auction, I purchased it, and I say OSFC is not doing the consequential thing. So therefore, I filed the suit for declaration and other things. Then trial court said, no, because earlier it was there in the name of the state government. So therefore, the state should have been as a party.
So how did it come to the name of Prasanna Naik?
But that has been dealt with at page appellate court judgment. Your lordship will kindly turn to paragraph 4.
Paragraph 4.
My lord.
After receiving oral and documentary evidence.
Internal page 4 of the lower appellate court judgment.
Internal page.
And I am also just, with your lordship's kind permission, putting a caveat in my submission in the same. These are all I am assisting. If at all he succeeds in the limitation.
You don't have to say it again.
I'm sorry, man.
I get your point.
Yes. Your lordship, after receiving oral and documentary evidence from the plaintiff and the contesting defendant number 2, the land trial court dismissed the suit with a finding that the suit land was conveyed in favor of the husband of the plaintiff in the year 1994 after the Hall settlement was held in the year 1984. In the Hall settlement record, Hall Khata number so-and-so has been prepared in the name of government, and thereby government is a necessary party for adjudication of the dispute. The government having not been added as a party, the suit suffers from non-gender of necessary party. The land trial court observed that when the suit land stands recorded as per Hall ROR, I stand corrected, Hall ROR, I am extremely sorry, I said pre-facto. In the name of the state, the action of the OSFC in creating a deed of conveyance of the land from the Khata number so-and-so in favor of the plaintiff's husband is not sustainable in the eye of law. He further held that the documentary evidence and all those things, may I, with your lordship's kind permission, keep it?
Please keep it. खाली मैं तो कही दूँगा जिनसे रखूँ.
तापर मैं खाली paragraph टा एठी देखिए खाली से perusal of record टा सेठी page 6 internal page 6 paragraph 8.
Yes.
से ता पूर्व paragraph से कहिले जे this recording neither creates nor extinguishes because it was a settlement recording. So far the Hall recording in favor of the state is concerned.
No. Again, my question is, it was recorded in the. You said it was recorded in the name of Prasanna Naik.
My
in the Hall ROR.
At the time he mortgaged.
So where does the state come into the picture? How does the state come into
the picture later on? That you will find that paragraph 8 it has been dealt with. Perusal of the record and evidence of PW1, the plaintiff as well as PW2, a boundary landowner, clearly establishes that on the date of filing of suit, the plaintiff was in possession of the suit land. Though the defendant number 2 disputed possession of the plaintiff in the written statement, did not refute the same by way of adducing evidence. The land trial court took a wrong view of the matter that plaintiff could not prove his possession over the suit land, ignoring that PW2 is a boundary tenant, and he fully corroborated the version of the plaintiff, PW1, that the latter is in possession of the suit land. However, the deed of conveyance marked as Exhibit 1 was created during an undisputed point of time, that is on 12/12/95. And that is what the language employed, undisputed point of time. The signatories in the deed are legal officers of the Orissa State Financial Corporation, the General Manager DIC Denkana. Both of them are responsible government servants, and the OSFC must have, after thorough inquiry, allowed the mortgage of the suit land by its lawful owner, that is defendant number 2. For the agreement relating to consequence of default, defendant number 1 OSFC took possession of the said and the same in favor of the plaintiff. No doubt all these activities were made after the Hall settlement ROs were prepared in the year 84. On the behalf of the plaintiff, a copy of the letter by OSFC to Tahsildar has also been marked as Exhibit 6, in which the Tahsildar was apprised about the execution of the deed of conveyance in respect of Sabik plot number so-and-so, recorded under Sabik Khata number so-and-so, requesting mutation of the same of the transferee. This clearly indicates that the government of Orissa had full knowledge about the said plots being transferred to the transferee, that is the husband of the plaintiff appellant. No objection was raised at any point of time by the state to establish that the transferee land belongs to the state. But this happened in 84, your lordship. During the trial, the plaintiff produced HAL Sabik plot index, the opinion received from the settlement office, which have been marked as Exhibit 3, 4, and 5 respectively. The learned trial court disbelieved these documents and came to a finding that there is no evidence that HAL plot number so and so, I am skipping that, as claimed by the plaintiff. But it is surprising that the learned additional civil senior division Nekanar ignored to take notice of the contents of Exhibit 4, which clearly shows that the HAL plot number so and so corresponding to so and so, part of Sabik plot number so and so. The information sheet prepared under the seal and signature of the assistant settlement officer marked as Exhibit 3 further reveals.
I get it. It was recorded in the name of Raj Sarkar, the king of Nagaland, thereafter.
So therefore, what I humbly beg to submit, the scope of the suit is completely different. That is nothing to do with the state government.
I will just ask one question to Mr. Das. Show me the ROR or any other document to show that at any point of time, the land was recorded in the name of the state. Raj Sarkar is different.
Yes.
That is prior to vesting. Prior to vesting, because he being the landlord.
Feudal state.
Feudal state. Nagaland was one of the princely states. So, after vesting, it came to be recorded in the name of that person or maybe he may have been in something. State may have given him the state may have given him some right.
Now, it's a revenue case. Revenue case order.
Revenue case because he may have been in possession. He may have acquired some right or he may have claimed some right, which the state accepted.
Much obliged. And state has never challenged those things. State has a forum to challenge also. And a suit or scope be not against the state. So state is not a necessary party, maybe a proper party.
I'll pass order.
I will submit certain citations of the Supreme Court.
Recess for it. After launch.
Again. Citation
Yes, on the Honorable Supreme Court has recently come up that the duties of the public servants who have not discharged it as...
No. My view, and with great respect to all the judgments of the Supreme Court, still that 1987, that land acquisition of Sir Anantnag versus...
Yes. That's
whatever that famous decision. 1887 or something, oft-quoted decision, we may have cited it in thousands, millions of cases. The point is, whether there is substantial justice is there or not. That is why I keep on asking, show me one document or demonstrate that the land belongs at some point of time. Then we will examine what Mr.
One more thing, they have not shown. Therefore, the case has to fail. They have not shown. That's what I was submitting.
Exhibit 5. Sabik Khata number 1 was Sabik Khata Exhibit 5 obviously corresponds to this HAL plot number.
Seta plot index HAL
Sabik correlation thibo seta. So Raj Sarkar jodi thila tabe likhile that means the king of Nagaland and by order passed in revenue case number so the record was directed to be prepared in the name of Prasanna Kumar Naik. So where does the state come into
State comes into picture
in the settlement ROR.
Whatever may be the subsequent developments. Had the state been implemented as a party, this could have been thrashed.
You show it to me. This court is satisfied, this court. We grant you that leave. If this court is not satisfied, why should they?
And the 2012 side that has been followed by this Honorable Court.
I know, many cases. Honorable Justice D. Das has followed it in thousands of cases. But not me.
I made in item 15 my case that is I 5 days delay.
It might close. Citations
I will be submitting and the record of right which has been referred to by the trial court.
85 record of right. There is no dispute about that.
So how did it
asking?
How did it antecedent? Antecedent, I am very clear. How did it then get recorded in the name of the state during settlement?
State has a huge property, state nare, leasehold property, same thing.
No. It is different. This is different. This is feudal property.
No document is shown.
No, Mr. Mishra. Since I belong to that area, I can tell you that. You cannot compare it with the Bhubaneswar.
No.
The total method is totally different.
Tenu se kahibe se revenue case re kemtla puni asila se chabi nahi. Kichi produce karna di apna par. Mu seita contention korthi. Leave application doesn't contain any material except reference to the trial court judgment.
That was drafted in 2020.
I don't understand why the plaintiff is fighting shy of.
It's not a question of shy of.
Impleading the state as a party and on content.
No. If I am convinced that state
has a say. No? If the state can have some right over the property, then I will grant.
But the other part your lordship will see also. But the scope of the suit, whether that the state should have been present at all or not. And
Because ultimately when it went to the name of Prasanna Naik, the state did not do anything about it.
So therefore, 18 of state contextual move, I am now, virtually I am going to die.
You are the auction purchaser. You are the auction purchaser.
But now, whether I should be made to suffer also.
All right, we'll see.
Because of
So, should I close it then?
Yes.
I will close, but I will be submitting, as your lordship wanted to know about some semblance of the state being recorded in the revenue record, that I will get it. Record of right.
Then I'll keep it to next week just for just
I don't know how can he supplement on the basis of my.
He won't. He can't.
There has been
Don't worry.
Supplementing anything. I am on the basis of the findings by the trial court.
Okay. All right. If you have copies of those exhibits, those relevant exhibits, not all. Exhibit 5 and that plot index. If you have those documents, heard in part, list this matter. It a limitation है लेकिन. IA 425 or 2020, heard in part, list this matter. We'll take it up next week. We'll complete it. You don't have to make further arguments. Only this.
मोर तंत्र क्या 5 दिन डिले अच्छे डिले नोटिस रे भी जाऊ तंत्र
2 3
आइटम 50 रे
ऐसे देखिए
डिले
The lordship, it was rejected on the basis that we have not submitted the surrender certificate. However, we have filed the surrender certificate, your lordship, on 11/7/2024. That has not.
Second number ऐसे देखिए.
Much obliged.
Be there. I don't think that is a surrender certificate which you are referring to. It's the order passed by the court below, showing that the persons did not appear. That is why NBW was issued.
Your lordship, thereafter, there's an order that we were taken to custody, your lordship, because were suffering from some ailment.
Surrender certificate कौन रहा है?
They had to literally drag.
How is that akin to a surrender certificate?
Your lordship, that
you were taken to custody on the strength of NBW.
Your lordship, to that effect also we had filed an IA, your lordship.
देखिए
Again.
तक रिजेक्ट है ये तक लॉन्च पर रखी अरे ये मैटर विल आल्सो टेक again.
Next week, in the next list, your lordship will get.
The next.
Okay.
No,
7 बाहर करो 46
observe that
46 ये था हाँ
again.
So
It is reflected that the accused Madhu Jena is suffering from severe hernia and undergone operation on 26/10 and he is required to take rest as per the advice of the doctor. The accused Ajit Jena is attending his wife who is admitted in the medical urology. So that is why they were not able to surrender on time.
So now you are in custody?
Yes, Your Lordship. I have been taken into custody since 13/1/2024. My only contention is since we are two brothers, Your Lordship, and we have been facing this trial, Your Lordship. So there is no other member, even to apprise us, Your Lordship, we are contacting them from jail custody. So, Your Lordship, the bail application may be restored, Your Lordship. And the status of the trial.
Bail application कौन reject है जी?
Again.
For default है जी?
No, just in the first half, Your Lordship was pleased.
Oh, all right, I'll adjourn it.
Yes.
I'll adjourn it. मेरे को तल कर दियो. List this matter. कौन कर दे?
28th August.
28th August.
Your Lordship may call for a report from the Hon'Ble Court in session as to status of trial, Your Lordship, because case is late.
28 तारीख को बितरा ही
21 witnesses to 12 जना examination they have supplied.
ताले अब कहीं
See that बहुत आगुरु हेतला. एबे trial टा जमा proceed करूँ. That is what is my contention.
ताले out के लंबा date करो.
11th September. 11th.
List this matter on 11th September. In the meantime, a report from the court below regarding status of the trial.
Much obliged.
Supplementary sala.
দেখো 26 একদম
I don't know, 26.
Lordship, please. My Lord, here the substantial question and issue was that whether on payment of an encroachment fine, Your Lordship will recollect that, whether on payment of an encroachment fine, even if that encroachment fine is paid under coercion or to prevent dispossession, will that amount to an admission of title by the state, thus negativing the adverse possession claim of the plaintiff? This issue, my lords, on the Your Lordships had heard briefly on the other day. I had conceded to the point of law, Your Lordships, pointed out that day that some judgments are there. In fact, they are there, Your Lordships, against me.
Entire thing is against you.
Yes. And there is no explanation forthcoming from the evidence as to the
You may claim
encroachment.
that it is I was coerced.
Yes.
But when you are staying on the land of the state,
yes,
and there's a OPLE proceeding,
Lordship,
you are required by law to pay.
And in fact, I have paid. And the fact of coercion also,
And once you pay,
there's an implied
admission of title.
Lordship.
So adverse possession by
Claim falls down. Totally falls down. Lordships may decide it if Your Lordships allows me to place the facts in brief, and thereafter, or a note that I can submit as Your Lordships find fit.
This is on the question of admission.
Yes.
Now, if I don't find any substantial question of law, why should I admit it?
Lordships.
As simple
No,
as
my lord, it was admitted, I believe, Lordships.
this has been admitted. How come? No.
Lordships.
This has not been admitted.
Question of law, Your Lordships had framed last occasion.
No.
Lordships.
They ଅଛି ଦେଖିଲ order sheet 11/7 ପରେ order sheet ଅଛି ଦେଖିଲ ବାହାର କଲ କଣ ହେଇଛି ଦେଖେ नहीं No, this was released in the matter in the week commencing 29 July. 26/7 कौन order पास है week commencing. No, nothing.
Again, I'll dictate करते my lord. My apologies, that's maybe I'm incorrect.
I had dictated the order.
Good. This is the substantial question of law that we will be framing. How we will take it up for hearing or
I may have said, but actually, no order may have been passed.
Maybe, I might be wrong.
No, it's all right. It's all right. But
that is the case, Mirat. Because I have also my learned senior on the other side.
Yes.
If it could be admitted, then it has to be some.
The point being this,
Yes.
what remains to be decided? What did the sub-judge hold? What was the suit?
It's an admission of title.
That suit for declaration of title, confirmation of possession, and permanent injunction.
Confirming judgments, my lord.
Oh, okay.
Or confirming judgments.
So he holds that
if you lord. Again, page 47.
Page 47, yes.
Again. The last paragraph, my lord, starts on the other hand.
Yes.
On the other hand, defendants number 1 and 2 submitted that the plaintiff was never in possession of Schedule A land. The ROR with regard to the said plot was properly recorded in favor of the government with due field inquiry and measurement, which is not challenged by the plaintiff before proper authority. The plaintiff himself, being examined as PW3, stated in his cross-examination that he is ready to pay fine to settle the land in his name before the Tahsildar Udala. Other words, he admitted that the land belongs to the government. It is the settled principles of law that adverse possession is a hostile possession by clearly asserting hostile title in denial to the title of the true owner. Then, Your Lordships, the line following, though the possession may be open and continuous, but it was never peaceful and uninterrupted, as claimed by the plaintiff. It lacks hostility. That is the finding.
The hostile animus.
Yes.
That has to be proved.
Yes. in adequacy, in continuity, as well as in hostility to the true owner's title. Nec vi, nec cam, nec precarium. My lord.
Yes.
So that third prong, my lord, I fail to satisfy.
Yes. Because and since this is a fairly well settled principle,
Yes.
that is why I find that it cannot be treated as a substantial question of law to be admitted.
Lordship. My lord.
And so the appellate court must have held the same thing.
Yes. Confirmed.
Though the state has nothing to say on the question of admission, yes. Yes. It has to be rejected only.
This is the when your lordship said asked me the position of law to be researched. I after doing this, my lords, I have found this judgment. This is the latest one.
I will not use this judgment.
Lordship.
This particular judgment, I will not use it.
Lordship.
I'll pass a judgment. You use it in some other case.
Yes, I'll do it.
So I'm dismissing it. Yes.
Intentions be recorded, my lord, that it was paid under coercion.
Yes. That is a brief order. This second appeal is by the plaintiff against confirming judgment passed by the first additional district and sessions district judge Baripada on 23/4/2022, followed by decree in RFA number 36 of 2016, whereby the judgment passed on 23/4/2016, followed by decree by the learned civil judge senior division Uttara in CS number 2 of 2008 was confirmed. For convenience, the parties are referred to as per their respective status before the trial court. The plaintiff filed the suit in question for declaration of title, confirmation of possession, and permanent injunction in respect of the suit land. It was claimed that the plaintiff's father had reclaimed and possessed the suit land, which was government land, and had occupied the same by constructing a residential house and also by digging a well thereon. After his death, the plaintiff's father and after him, the plaintiff paid revenue to the government and obtained rent receipts. The father of the plaintiff is said to have acquired the possessed the land from 1950 onwards. He having died in the year 2001 and the plaintiff having possessed the land thereafter, the total period of possession would be more than 50 years. In the settlement operation, it was further claimed that the settlement authorities committed in recording the suit land in the name of the state, as also by changing the kisam of the land. Final public ROR was finally published in the year 1987, whereupon lease cases were lease case लिखा था हाँ ठीक है lease cases were start, and on the basis of orders passed therein,
lease was granted in respect of the land, in respect of portions of the land,
Yes.
to defendant numbers 3 to 8. This is more or less correct, Mr. Das?
Yes.
Correct me where I am wrong. Claiming that the defendants have never possessed the land, nor have any manner of right, title, or interest, the plaintiff filed the suit. Suit in question. Para.
Your Lordships, that in those lease cases, portion of shoot land was also settled in favor of the plaintiff.
Last line the it is also claimed that a portion of the portion of the land leased out was also settled in favor of the plaintiff. Who's defendant number 2? The state. Naki.
Again.
Defendant number 2 is the Tahsildar.
Tahsildar.
Defendant number 2 being the Tahsildar of Udola. No, সেটা নাই। নেই লিখুন তারপরে তা পূর্বর আছে না এনক্রোচমেন্ট নোটিশটা আছে না সেটা আমি লিখি না এন্ড দ্য সুটটা কেটে দিন therefore the petitioner filed the suit কেটে দিন further the Tahsildar Udola notice under section 7 of the OPLE Act and initiated an encroachment case against the plaintiff. It is alleged that the plaintiff and his father were forced to pay the fine as imposed in the encroachment case. Stop. On such facts, the plaintiff filed the suit claiming the relief as already stated here in before. Para. Defendants filed a joint written statement refuting the claim of the plaintiff. It is stated that the land in question is a government land which neither the plaintiff nor his father ever reclaimed or possessed. Further, no Amalnama case was initiated in the year 1950. Therefore, the question of acquiring right, title, and interest and possession does not arise. The settlement authorities rightly accorded the suit land in favor of the government after due field inquiry and measurement. Since the are landless persons, they were provided with lands according to lease principles. On the other hand, encroachment proceeding was initiated against the plaintiff. Stop. Yes. Basing on the pleadings, the trial court framed the following issues for determination. Para. Taking up issue number 3 at the outset, the trial held that the plea of adverse possession raised by the plaintiff in respect of the suit land has no legs to stand for absence of the necessary ingredients thereof. Under the remaining issues, the trial court held that the plaintiff is entitled to land measuring accord 0.05 decimals, all plot number 7, Hal Khata number 338, which needs to be added to Hal plot number 13, Hal Khata number 22, in the name of the father of the plaintiff. Stop. On such findings, the suit was decreed in part. The plaintiff carried the matter in appeal. The first appellate court, after noting the contentions raised, was also of the same view that yes, the plea of adverse possession was known to the ancients. We have in our book, the Judicial History of Orissa, we have mentioned it. You must go through that book. Not only principle of adverse possession, principle of constructive res judicata was also known to them. And cases were being decided in the ancient period by adopting such principles. Now, according to some, possession follows title. According to some, the reverse is true. Title follows possession. Those things were all, don't think that they have come to us only from the British. It's very interesting. You can have a book of, it must be available in your house. You must read that book. Yes. We put in a lot of effort to compile all those things. Hello, as the trial court. And held that he has also held the same thing.
Yes, page 47.
Page 47.
I'm so sorry, Let's see. It is
No.
that.
Held that by paying a penalty in the encroachment cases initiated against the plaintiff, there is implied admission of title of the state, for which the claim of adverse possession would not stand. On such findings, the appeal was dismissed, and the judgment of the trial court was confirmed. Being further aggrieved, the plaintiff has approached this court in the present second appeal. Heard Sri Abhishek Das, learned counsel for the appellant, plaintiff appellant. Stop. Sri Das would argue that it was the specific plaintiff that the penalty paid in the encroachment case was out of coercion and pressure, as there was apprehension of loss of possession. Stop. The state being in a dominant position, the plaintiff not have refused to pay the penalty. Stop. Sri Das further argues that under such circumstances, it cannot be inferred that the plaintiff had admitted the title of the state, more so when there is evidence to suggest that his father and after him, that he and his father were in possession taken together for more than 50 years. After going through the impugned judgments, this court finds that the claim of the plaintiff
appears to be based on the so-called Amalnama case number 1925 of 50, whereby the suit land was said to have been allotted to the father of the plaintiff. This is the case?
The case is that portion of that land was allotted to the plaintiff and his father by the Amalnama case. On allotment of that land, along with the suit lands, they continued to be in possession for more than 50 years.
The further claim is that the plaintiff and his father also possessed the suit land along with the land so allotted Amalnama case thereafter. Stop. The exact date or period of such possession is not forthcoming. Stop. Be that as it may, there is clear evidence that encroachment case number 1507 of 1994 was 1507 was instituted against the plaintiff, and encroachment case number 173 of 1998 was initiated against the father of the plaintiff, wherein they were directed to pay fine and penalty. It is not disputed that such fine and penalty were paid by the plaintiff and his father. Stop. Though it has been claimed that such payment was under duress and coercion, but there is no such evidence to substantiate such plea. As such, the payment of fine and penalty would amount to admission of the title of the true owner, in this case, the state. Stop. It is needless to mention that to maintain a plea of adverse possession, a person is required to prove long, continuous, uninterrupted, and peaceful possession with hostile animus against the true owner. Stop. In the instant case, even if it is proved, even if it is accepted that the plaintiff and his father were in possession over the suit land for a long period, yet once the factum of payment of fine and penalty in the encroachment proceeding is proved, the plea of exhibiting hostile animus automatically falls to the ground. That's all. Both the courts below have rightly held so. Stop. For the reasons indicated above, this court fully concurs with such findings and therefore finds no reason to interfere with the impugned judgments. So, for the foregoing reasons, therefore, this court finds no justified reason to admit the appeal, much less on the ground raised by the appellant. Stop. The second appeal is therefore dismissed. Pass on that judgment. Say judgment or okay. Same thing.
Lordship.
Check. In a different language. Okay, same thing. The hostile animus kotha likha. The court appreciates your fairness, Mr. Das.
Number 28.
28.
My lord.
Kali ହେଇଥିଲା ଏଟା argument ହେଇଥିଲା?
Pass over ହେଇଥିଲା କାଲି last half ରେ ପଡିଲା ଟିକେ pass over ହେଇଥିଲା.
28, yes.
My lord, this is against a confirming judgment, my lord. This suit was filed by the plaintiffs, right, title and interest about the A scheduled property on the plea of adverse possession, my lord. What has happened, my lord? One Durga Prasad Mishra was the then Lambardar Guntia, my lord. He issued a Hathapata in favor of the grandfather of the present plaintiffs, my lord, on 5/10/1940, my lord, for an area of 4 acres of land.
4 acres.
4 acres of land. That was possessed by the great grandfather of the present 1A, 1B, and grandfather of the plaintiff number 3 and 4, my lord. After their death, my lord, the petitioners were in cultivable possession, and they possessed the same. Till they are now also they are continuing, my lord. However, it was wrongly recorded in the government khata in major settlement, my lord. Thereafter, 80 CPC notice was issued. Thereafter, suit was filed. The learned trial court, my lord, after suit was filed, my lord, notice was issued to the opposite party, the state, collector, principal secretary, and Tahsildar, my lord. They did not choose to file any written statement, my lord. And they contended that it was recorded in the name of Fishery Department, my lord. Since there was no evidence at all, my lord, the learned trial court also disbelieved that, my lord. There is finding to that effect in the judgment itself, my lord. However, Exhibit 1, that is the Hathapata executed by the then Lambardar Gauntia Durga Prasad Mishra, that was not taken into consideration by the learned.
Genuineness of Exhibit 1 is to be determined by the court. No doubt, the Exhibit 1 has been executed by Lambardar Gauntia. Means a person appointed in the manner to whether to provide to body from section 130.
Page 22.
He says that he is not authorized to issue any Hathapata. That is the finding.
That is the finding. But the appellate court, your lordships, kindly, I will bring to your lordships to para 17 of the appellate court.
No, before we do that, what is your response to this? That the Lambardar, as per the statute, is not authorized to. He is to collect the rents and all that. He is not authorized to. What is the county after all? Corresponding to Sarvarakar of our area, isn't it? Amara Sarvarakar ja sepote county council. Amara bhi county council.
They were given some landed property.
They were given a rent-free lands for the purpose of collection of revenue.
For the purpose of.
Did they have any right to issue a Hathapata?
They were issuing and.
The court below holds that they did not. So, what is your response to that?
My response would be, my lord, Hathapata was admittedly issued by the Gauntias, on the basis of which so many have been recorded in favor of tenants, my lord. Till now, the RORs have been issued in favor of the tenants, my lord.
Anyway, what is the appellate court?
Appellate court of your lordship may turn to para 17 and 18, my lord. Para 17, may I please, my lord?
Para 17.
My lord.
Yes, please.
It has been adduced by PW1 in his evidence in shape of affidavit to the effect that the forefathers of the plaintiffs, while possessing the land given to them by Exhibit 1, they also possessed another area of 3 acres and 46 decimals of land out of said home settlement plot number 17, which have been recorded in the major settlement plot number 121241, area of 5 acres 42 decimals, major settlement plot number 1243 having area of 1.26, so and so, by way of cultivating and plantation of trees. Thereover, till their death, and thereafter the present plaintiffs are and have been possessing their share of landed property as per their amicable family settlement, and they have also perfected their title by way of adverse possession. Such evidence of PW1 finds support from the evidence of PW2. Thereafter, next para, variety. Be that as it may, on perusal of the evidence of PW 1 and 2, it emerged that the purpose of the plaintiff were in permissive possession over the portion of the suit schedule land, with respect of which the plaintiffs claim to have been issued Exhibit 1. However, it is the positive case of the plaintiffs that they claim to have perfected their title over the entire suit schedule A land, which includes the lands claimed to have been transferred to them by Exhibit 1. Nothing is there on record as to since when the said permissive possession turned to adverse possession by the plaintiffs. But there is that matter that quota was issued specifically on 1940 madam, 5/10/1940 madam. That is the starting point, madam. Until now also they are in cultivable possession. This is the wrong finding, madam, of the learned appellate.
But you have not yet answered my question. Your entire claim is based on that Hathwata by that number.
Exhibit 1.
Number. So this is under that Central Provinces Tenancy Act. We have to see whether he was authorized to.
I will verify, madam.
On that part. If that fails, then adverse possession. There's a question of permissive possession. Kotha kahi selection.
Seta lepujante permissive possession kotha. Seta wrong fact.
Third and part on the question of admission. Does this matter? In the week commencing 27th August. You can take down another book. This contains the revenue settlement systems available in different provinces. What was there in Hon'Ble? What was there in Sambalpur? What many central provinces? What was there in the south? South re kon thila? Madras States Land Act thila. Epote thila amaro Bengal Tenancy Act followed by Odisha Tenancy Act. Central provinces re sim tolga thila. You go through, find out. Number that or whether he was authorized to issue a Hathwata. Hathwata man lease boli kono. It is basically a lease.
Second of all, I would 384 by 18. Honorable Justice Chittaranjan Das delivered one judgment.
Yes.
Can issue Hathwata. I will bring.
Please bring it.
I don't know, 33.
33 is Gopinath Sethi. Mr. Namtor. Yes. Argument. This was being argued yesterday, Mr. Namtor.
Yes, Lord.
What was the point?
We are hooked on that point. Whether the registered shall deed will hold more water or section 90 of the Evidence Act in which I've gone through it and I can't reach to any conclusion yet. Now, one thing is that both are in the statute, 11 and 15. And I think this portion is very much debatable and it will.
No, not a question of debatable. Evidence Act is a general act. Registration Act is a special statute.
Yes.
Without prejudice to your claim, I can ask these questions to stalwarts like Mr. Mahanti, Mr. Das in the civil law. Without prejudice.
Yes, Lord.
But I have my doubt. You can. I mean, this is not my final opinion, but I have my doubt. Non-registration will never be cured by that 30-year thing.
It is not. It cannot be cured. What the problem is? Now, let us say a 30-year thing has been made earlier, and knowingly that has been registered with somebody with.
It can be used for collateral purposes. It can be used for collateral purposes. There is no dispute about it. The document can be used. I think section 49. Section 49 is the section.
1990.
Section 49 for collateral purposes. Registration Act. But
because in admission also, section 17 says an admission is a statement orally or documentary which suggests any interference as to any fact.
What I would suggest is, sir, please examine it further. I may be wrong. I'm not saying that what I'm saying is right. Maybe wrong, but this is the doubt that has. That is, I mean, I'm confronted with that doubt.
Yes. And is a statement orally or documentary which suggests any interference as to any fact in issue or relevant facts, and which is made by any of the person or under circumstances thereafter mentioned. So anything can be admitted, whether orally or whether documentary, if it has some evidentiary value. Section.
Please examine it again.
We'll keep it to next week.
1 week after, next week I may not be there.
Keep it to-
I will commencing 20th August.
We commencing 20th August. All right. Heard in part, this is matter. It admission in the week commencing
20th August.
20th August. Very interesting point. Let us examine. You may get some decisions also. Yes.
I don't know, 34.
34. Your matter.
It's an interesting suit. Defendant did not appear in court below, but my suit dismissed expert. I prefer an appeal, my appeal is dismissed. Parties are relatives, sister-in-law and nephew.
What was the suit for?
Suit for ejectment simple sitter. Plaintiff said, plaintiff's admitted case, that is also the finding of the courts below, that this particular suit house, he got it from housing board out of his own income, leased from the housing board. Now, out of kindness from in the time of their penury, he allowed the sister-in-law because the brother died. Sister-in-law and nephew were allowed to stay in that house. They did not vacate it. So he was constrained to file the suit for ejectment.
What happened here?
Now the courts below are saying that this suit can only be filed by landlord tenant, nothing else. And that is one. Two, one more ground they have rejected is a partition suit is filed by them, which is pending in the court below. If a partition suit pending, the courts below, I mean the appellate court or the appellate court could have consolidated both the suits in exercise of power on section 24. So that there will be complete adjudication. If partition is given in their favor, they will get it. Not given, they will vacate it. So instead of consolidating both the suits in exercise of power on section 24.
Yeah, because since you style your suit as an ejectment, I think ejectment, usually it is filed, there's a suit is between the landlord and tenant.
Check, that's suit for eviction.
Eviction.
That's suit for eviction. Here is a case, I have filed the suit on the basis of a landowner. And it's a permissive position. I have allowed you to stay over there. That doesn't mean that you will not vacate it. There are two contingencies here. One is either by of a mandatory injunction you can be removed, section 39 of the specific relief act, or say the theory of licensee will come into play. So instead of examining all these matters, if you are finding that there is a partition suit pending,
well, it will admit it.
Right.
Point number 1 and 2.
That will do, man.
Let's see. P.K. Rothel and senior counsel with
S. Das.
Ms. S. Das, and counsel for the sole appellant.
Sole appellant.
Appellant. Peruse the impugned judgments. Considering this and the grounds raised, the second appeal is admitted on the following substantial questions of law. It is page 7. 1 and 2. Issue notice to the respondent by registered respondents by registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days. Call for the LCR. Is this matter?
In the week commencing 28.
In the week commencing 28th October.
143 is there. If I am not there, may kindly accommodate for the day today.
Yes. It's in the weekly list. And she is there, she can argue.
Yes, but I don't think she is ready in that way. Normally she gets ready. Normally she is ready, but today I think.
Today to jaha she ro dhariba ame. Yes.
Item 35.
Lordship, it may be possible for the day, Your Lordship.
No, admission.
My senior would do the matter.
Why? For admission, why are you not prepared?
Lordship,
You should prepare.
Lordship,
Second appeal, if you are getting a chance, you should prepare. All right. I'll call it tomorrow. Tomorrow you argue. I'll not allow Mr. Das to argue. All right. Prepare. Don't worry. If there is any difficulty, the court will help you. Don't worry. But prepare. Make an effort. Yes. Pass over.
Item 36.
May it please, Your Lordship.
Dita matter.
My lord, Dita related here.
Yes.
Your Lordship, I seek Your Lordship's kind consideration for this case. Because a party has suffered her for none of his fault, only for a simple mistake committed by the conducting counsel. The mistake is that the plaintiff parties are dead, so they are legally plaintiff are substituted, but I am referring them as plaintiff defendants.
So, dead before the court below.
Dead before the court, substituted accordingly.
All right.
My lord. The plaintiffs filed a suit for declaration of title based on the registered cell deed executed.
You are the plaintiff?
I am the plaintiff.
Yes.
Plaintiffs filed a suit for declaration of title and permanent injunction based on the registered cell deed executed by the defendants. Now, the conducting advocate in the learned court below, there are 4 cell deeds. So, first one is relating to 1 cell deed, second case relating to 3 cell deeds. The conducting advocate, my lord, committed a mistake. Cell deed number and the date he wrongly placed. So, my cell deed in first case is cell deed number 766 dated 25/5/87. But he wrote it as 24/4/84, which is cell deed number, which is date of another cell deed in the case number 2. Now, the learned lower court entirely disbelieved my case, though I exhibited that cell deed, but the learned lower court said that 24/4/84 cell deed you have not produced. That I cannot produce it because it is 25/5/87 766.
Yes.
So I preferred, I lost the case. The learned lower court didn't believe it and I lost the case.
Yes.
I preferred the first appeal. With utmost respect, your lordship, to some extent, the learned lower court is not wrong because the wrong cell deed number was there. So even if I have exhibited, the learned lower court have taken into consideration that it is a typographical error, but the learned lower court rejected. I carried the matter in first appeal before the learned district Dharmagad. Now, during pendency of the first appeal, I filed a petition under Order 6, Rule 17, so also Order 41, Rule 27. It was rejected. I came before this Honorable Court. This Honorable Court considered error. So, with all observations that this should be allowed, the learned lower court, it was remitted back to the learned districts for consideration again. The learned districts has been pleased to consider and allowed it. So, my plaint has been amended. And accordingly, some additional documents I wanted to adduce, that ROR and other documents, those were also allowed. Thereafter, nothing remained irregularity in my case. But this mistake I have committed, that carried heavily in the mind of learned lower courts. So, ultimately, even the learned districts has been pleased to reject my case.
You will call for the LCR?
Your lordship, yes, my lord.
I'll call for the LCR so that once you can satisfy the court on verification of those exhibits, I'll admit it. I'll admit it. Even if it is admitted, notice to Jibo. This has to be remanded probably.
Yeah, that is exactly observed by the learned districts. It should have been remanded. But then the learned districts went on saying that instead of remanding, it would be better if appellate court decide. That is exactly your lordship the finding.
Okay.
And your lordship may kindly see there are certain other points also. A cell deed is never required to be attested. That is not a document compulsorily attestable. Unlike mortgage deed and gift deed.
Yeah, attest witness sign करते ना.
Seller sign करते purchaser sign कले. It is unilateral document even a seller can sign.
Yes.
But attestation is not compulsory.
No, absolutely not.
But the learned, because I got the cell deed attested, the learned lower court and as well as the learned first court, they relied heavily that the attested document should say, attesting witnesses should say everything. Even if, my lord, it is considered it is attested, then attesting witness need not say anything about the contents of the document. Attesting witness put the signature animo attestandi only with an intention to attest the signature of the executant, nothing else. But there is a clear finding that they should say the contents of the document. If your lordship will permit me, I will place that line only. Page 21.
21.
Okay. The 10 number paragraph tag coach. Usually the role of attesting witness is to identify the vendors and transfer.
No, where are you reading from? Page
21 again. More page 21.
Or the
serial number. More second appeal serial number. Internal page 9, judgment 9.
9, or set up one.
Okay. Paragraph 10, my lord.
Yes. Usually the role of the
attesting witness is to identify the vendor and property transfer. With respect, your lordship, it is never the case. Property transfer se kebe bhi kohibe nahi. Your lordship may kindly see.
They only attest the execution of the document.
Only that much. Kete consideration diya hala, kon diya hala, property ro north, south, west, east. Attesting witness cannot say. And your lordship may kindly see, se jo moro discrepancy kohuchanti, seita my lord may be kind enough to consider.
So we'll do one thing, Mr. Mishra, we'll call for the LCR.
Okay.
At this stage, we can call for the LCR and then we'll see those documents which you are, now they cannot be imagined.
No,
It has to be seen. If you have certified copies, you can show it now. Or
the certified copy and mara exhibit uda achi mo par so.
Certified copy uda.
No, certified copies.
Let us call for the LCR. We'll see the then.
But then your lordship may kindly consider the IO.
Yes, certainly. No, otherwise you want it to be admitted.
Mora heijibo again. Your lordship will consider. Can say again, this is a cell deed executed in 1984.
All right.
Suit in 2000.
All right, I'll admit it. Heard Sri Ashutosh Mishra, learned counsel for the appellant. Appellant or appellants?
Appellants. Other
appellants. To use the impugned judgments, considering the submissions and the materials on record, considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. এটা করন্তু এটা করন্তু C করন্তু D করন্তু that will I think suffice
my lord F টা মুড়িকে
no and F
টা মুড়িকে ঠিক রে লিখি পারনি কারণে
ঠিক আছে থাও whether a deed of sale registered under section 17 of the Indian Registration Act is required to be attested under section 54 of the Transfer of Property Act.
It actually mean କରିବାକୁ ଚାହୁଁଥିଲି ଯେ whether attesting witness should say anything else.
F ଟାକୁ ଲେଖିଛନ୍ତି whether attesting witnesses to a sale deed are required to adduce evidence with regards to the property
and consideration.
The property and consideration relating to the sale deed. है ना? सती को issue notice to the respondents by registered post with AD returnable within 4 weeks. Requisites be filed within 3 working days. Call for the LCR. List this matter on 28th October. IRA Lakhantu, notice as above. Status quo with regard to the suit property shall be maintained till the next date.
Again. Next case re aro tinta cell deed ro
same order to ho
again.
Yes.
So point of law is saman.
All right.
Item 37.
Next case re also I have filed an IA.
Same order habo. Detail same order.
Item 37.
Pass over.
Item 38.
In item 38, state is the other side. I've given a copy of the appeal memo in the last occasion.
So you argue.
Well, argue there is no point in my case. I have to make out a point.
Argue, so I'll have to pass a judgment. I cannot say that Mr. Balkrishna said that he has no point.
Yeah, because there is a suit for permanent injunction of movement. I'm the plaintiff appellant.
Yeah, what was the substantial question of law?
Substantial question of law is A and B.
Whether the landlord courts will have decided the suit for keeping in view the provisions of section 38 of the Specific Relief Act. Manifestly, the courts would have ignored the said provisions of 38 as such the decree Pashmala. The facts of this case, the findings related to possession are based on documentary evidence. Documentary accompanied with oral evidence, clear plaintiff's title and possession.
Here the whole story is that a road is there, existing road is there. Besides the road, my land is there. So upon mine, half of the land, 7 decimals of land, title deeds have rejected only basing upon one issue framing framing on one issue of finding has rejected the entire case.
Yes.
That is the sum and substance of the case.
What is the finding of the trial court, basically?
Issue number 2.
Yes.
Is that page number 10 of the trial.
Yes,
court.
yes.
Can I place it?
Yes,
It's
please.
a lengthy.
That खाली main portion, the relevant portion. I have understood your matter. So I just want to know on what ground was the trial court, on what ground the trial court.
Because I have filed MS Patta. That is shall not be taken into, because the Patta which was with me, I filed it for correction before the concerned authority. That I have not filed it. That is the sole question. Page 14.
Yes.
Towards the middle. Law is now well settled.
Yes.
Law is now well settled. The decision of the decision of title and possession of consolidating authority is binding on the civil court. Even if the decision of the lower authorities of the consultation is stayed by the higher authorities or under challenge before the higher authorities, and the decision of the lower authorities, this stands even if revision against the decision is pending before the Commissioner of Consultant. PW1 further states that he has not filed the consultation map or purchase, as because landowners of the suit land are possessing the land as per the MS ROR. And the consultation scheme is not yet worked out in the suit village. Here, what I submitted is that rightly or wrongly, the land is in my name. Land is mine. Only khata number and plot number has to be changed after the patta is to be given. That because the trial court has said that because you have not filed that ROR, there is no clear title. That's why he has rejected, and the rest of the issues also have been rejected. That's the sole question. And the government, the BDO has not denied my plaintiff amendments. He said it right, correct. Has not denied my.
What about the appellate court?
Appellate court in total has gone. Has taken up that issue. At page 5 of the appellate court, he has mentioned.
They have disbelieved your claim of being in possession of the suit land. So this is a finding of fact. Purely finding of fact.
Yes, true. I don't deny, but I have filed that map, the road. The road is existing. I don't say no, but the road has gone. Some of the portion of the land they have taken. That is the thing. That BDO has not disbelieved my submission.
As the first appellate court has held,
yes,
when it was in dispute that the suit land was a portion of the village road, and it came out in evidence that the said road existed as it was since long, the plaintiff could have got the land demarcated through a surveying commissioner in order to find out the actual position.
I don't say.
That having not been done and the own evidence of the plaintiff being against him, I do not find any persuading reason.
I said I have a weak case.
Anything you want to say, Mr. Das?
Yes.
As your lordship had pointed out rightly from the appellate court judgment, so more or less a case of demarcation. As
no, but he did not take that step. He should have filed a 26-9 petition at the appropriate time.
That is correct.
That would have sufficed.
Survey commission.
That would have sufficed. Why did you do it?
Lack of.
Yeah, maybe. No, this is from Burgard. You cannot say that. Burgard counsel are very sound in civil law. Yeah, yes. I speak from my experience, having dealt with some of them.
Don't say.
Wrong advice, maybe. But what do you say? Will
Judgment be reserved.
Yes.
Judgment be reserved.
It's a server judgment. Okay,
How?
Yeah.
Something between.
All right. You want a adjournment?
No, not adjournment. I have gone through it, everything. Basing upon the map which has been filed, the lower court should have come up.
No. No, you see, at that point of time, consolidation operations were going on. It had not been finalized. So how could the map be relied upon? And your claim is based on the fact that you say that the villager or portion,
7 cents, 7 decimals.
whatever, a portion of the suit land, a portion of the road has been, your case, land has been included in the
road. Whereas the other portion, defendant number 1, has built a house on the road itself.
No, that's it. How are you concerned?
No, I'm not concerned, but I have to place my case. ठीक है से रोड टा घुंची गला चौड़ा जेती हवा कथा से मापी देले
To be very fair to everybody, this should not have been admitted.
ऐसे के क्वेश्चन जजमेंट रिजर्व था
ये कल मत फोन करे पड़ो ना
छुट्टी 3 दिन
No. I never keep my judgments pending for long. Sometimes it happens, but normally I try to give my judgments as quickly as possible. Lady Boston, they didn't take the produce and take the weekend. You think the point of the point?
See, it is the Hong Kong 38 I would have taken up that point.
What 38?
38 of the specific relief at granting of injunction. But
No.
title has been not.
You have not proved possession. According to the court's below, and I don't find no reason to interfere with their findings. So unless possession is proved, 38 ko ta asme kutu.
See, I didn't press the 38.
All right. We'll dictate the judgment. Please correct me if there is any factual error. This is an appeal by the plaintiff against a confirming judgment passed by learned additional district judge bracket FT Bargod in title appeal number 10/42 of 2001-02 on 38/2003, followed by decree whereby the judgment passed by learned civil judge junior division Bargod on with the date on 14/3/2001, followed by decree in title suit number 29 of 2000 was confirmed. For convenience, the parties are referred to as per their respective status before the trial court. The plaintiff filed for permanent injunction against the defendants. Stop. The case of the plaintiffs is that one key Korno tha na, Badi Korno. One Badi Korno had two sons, namely Chaturbhuja Korno and Modern Korno. After death of Badi, the ancestral property of the family was amicably partitioned between his two sons, whereby ekor 0.19 decimals of land appertaining to MS plot number 302 na 382 562 562 along with other lands appertaining to MS holding number 19 fell to the share of Chaturbhuja Karna. He came over, he was in exclusive possession of the same till his stop. After his death, the plaintiff, being his son, succeeded to the property.
Yes.
And Sri A.R. Das, learned
or respondent number 2 and 3.
counsel, learned AG appearing for respondent number 2
And 3.
and 3. Who has appeared for respondent number 1?
None. But notice was made sufficient.
Despite sufficient, there has been no appearance from the side of the respondent number 1. Sri Balkrishna assails the impugned judgments by submitting that both the courts below have been swayed away by the fact that the consolidation map of the area in question was not produced by the plaintiff, and so also the consolidation ROR. Stop. It is also submitted that the trial court ought to have considered the other evidence adduced by the plaintiff showing his possession. The first appellate court also by drawing adverse inference against him for not getting the land demarcated by a survey knowing commissioner. According to Sri Balkrishna, the factum of possession could not have been proved by a survey knowing commissioner alone. Stop. Yes, what is your contention? Mr. Das, say something.
That there is no substantial question of law. Look into the findings of both the courts.
Yes.
Comes a more or less a question of fact, appreciating the facts.
Sri A.R. Das, learned AGA, submits that both the courts below have found from the evidence on record that the plaintiff was never in possession.
That portion of land in dispute. And
he was never in possession over the suit land.
Suit land
was never in possession over the relevant portion of the suit land. This being a pure question of fact and being based on the evidence on record, this court need not interfere in the matter. Having perused the impugned judgments and upon hearing learned counsel for the parties, this court firstly finds that the plaintiff claims to be in possession over a portion of the suit land which was allegedly encroached by the state ostensibly for the purpose of construction of a road. Hence, the question of possession becomes vital to prove to sustain the case of the petitioner, the plaintiff. The area in question was under consolidation operations, which appeared to have been concluded at the time of hearing of the suit. The trial court drew adverse inference against the plaintiff for non-filing of the
trial court has taken note of my contention.
Yes.
That I have not filed a
map. ROR also. That is what I'm saying. Drawing adverse inference for non-filing of the ROR consolidation. ROR.
Appeal is pending. I have filed it for correction of the.
No. Only, Right. Drew adverse inference. The plaintiff for non-filing of the consolidation ROR and the map. Stop. According to Sri Balkrishna, the plaintiff could not have filed the said documents as he had preferred an appeal, which was then pending.
Right.
But then this court fails to understand as to what prevented the plaintiff to file these documents before the first appellate court. If it was at least, if they were not available during the trial of the suit. That apart, the plaintiff could not have his possession over that portion of the suit property which was used as a road. Stop. That apart, it is borne out from the evidence on record that the road in question was not being constructed newly, but was an old road constructed for the use of the villagers since long. Stop. This court, as has been held by the first appellate court, and according to this court, rightly so, the plaintiff could also have got the portion of the suit land demarcated by a survey knowing commissioner. But he did not do so. Under such circumstances, both the courts below have held that the plaintiff could not prove his possession over that portion of the suit land which was used as a road. From what has been narrated here and before, this court fully with such findings. Moreover, these are all factual findings, and it has not been demonstrated as to how such findings are incorrect so as to persuade this court to interfere. Stop. It is well settled that the second appellate court would always be slow to interfere with the concurrent findings of fact unless it is shown that such finding is either perverse or against the weight of evidence on record. Stop. Such is not the case. Such is not the case in the present appeal. For the foregoing, this court finds no merit in the appeal, which is therefore dismissed. There shall be no order as to costs. So, अच्छा हो 39 directly?
Item 39.
Previous item 37.
37 कौन इधर है?
37 second of three. That is not rejection.
Mr. Mahathi, नहीं जो ऐसे था, वो admission टा अच्छी नहीं जो, admission टा अच्छी नहीं जो, कौन?
Let's say the appellant was preferred an appeal challenging the order of the law on trial before the
past appellate court. In matter number 1 of 2017, and that has been dismissed, Lord, running page 17, Lordship.
Just a moment.
Running page
This is Mata.
Lordship.
Mata before Civil Judge Senior Division in Barampur. Is there a family court there?
Yes, sir, the challenging the order passed by the civil judge senior.
Is there a family court ଅଛି ବେ?
ନାଇଁ ଫ୍ୟାମିଲି କୋର୍ଟ ସେଇଟା ଫ୍ୟାମିଲି କୋର୍ଟଟା ଅଲଗା ସିଧା ହାଇକୋର୍ଟକୁ ଆସିବ ଆଉ କିନ୍ତୁ
ନାଇଁ ନାଇଁ ଏଇ ଯୋଉ ସିଏମଏ ଟା ଫାଇଲ କଲେ କଣ ପାଇଁ?
ସିଏଟା ରେଷ୍ଟୋରେସନ ଅଫ ଦି ମ୍ୟାଟ୍ରିମୋନାଲ
ମ୍ୟାଟ୍ରିମୋନିଆଲ ସୁଟଟା କୋଉଠି ଫାଇଲ ହେଇଥିଲା?
ଡିଷ୍ଟ୍ରିକ୍ଟ ଜଜଙ୍କ ପାଖରେ
କେମିତି?
ଲର୍ଡସିପ
କାଇଁ?
ନାଇଁ ସେଇଟା ଯଦି ଇଏ ହେଇଥିବ ତାହେଲେ ସେଠି ଯାଇକି ଆସିବେ ଫ୍ୟାମିଲି ଜଜ ହେଇଥିଲେ ଏଠି ସିଧା ଆସିବେ
ମୁଁ ସେ କଥା କହୁନି। ଅରିଜିନାଲ ସୁଟଟା କଣ?
ଅରିଜିନାଲ ସୁଟଟା 13 application 13 application for decree of divorce.
ସେ କୋଉଠି ଫାଇଲ ହେଇଥିଲା?
See before senior division.
କେମିତି?
Both the way.
ନାଇଁ ମୁଁ ବହୁତ ହେଇପାରିବ?
Oh, yeah.
Oh, Mr. Mahathir, what are you saying? There's a notification. Once that notification is there, the power of the civil court ceases.
No, it is the of the year 2013.
2013 ରେ? 13 ରେ family court ନଥିଲେ ବରହମପୁରରେ? ନଥାଇପାରେ, ତାର ଠିକ ଅଛି, ନଥାଇପାରନ୍ତି। Let us see.
Running page 17, Lordship.
Running page
17.
The appeal is
appeal that has been dismissed.
trial court order कहीं?
Trial court order, Lordship. Then the running page 18, annexure 3. The restoration application CMS 7 of 2022.
Oh, so that restoration was rejected?
Rejected only on the ground of delay of 48 days.
Whatever. So you carried an appeal
Plus
to the district court.
Plus
That was again rejected.
No, the district judge has rejected the.
No, se kuch bas. Na, apna agar CMA file kale, CMA ta reject hala.
Reject hala.
Against that you went in. So second appeal lies against that order.
Plus.
I don't know. I'm asking you. So that was a contested matter.
Plus.
Let me issue notice of confidence. On what ground it has been dismissed by the district judge?
Only they have stated the only 48 days of delay.
No, district judge कौन पे reject करे?
केवल से गोटे ग्राउंड जो ओरिजिनल सूट dismiss.
ना ना.
Running page, Lordship. Running page 17, Lordship.
The appeal was pursued, non appears limited, hence the appeal is dismissed under order 41 rule 17 of the CPC.
Plus. The defendant of appellate.
For the default of the appellant. So dismissed for default.
Plus.
Is there a substantial question of law?
Because in fact, that has not been decided in merit. I am mentioning the substantial question of law, only the 3 grounds I have created.
No, that is the first question that I asked you.
Running page 6 of my petition.
No, that's the first I asked you whether the civil court has jurisdiction.
The law and trial court has already issued the frames, Lords. Running page 4, Lords, in paragraph 5.
All right, but this will no longer be a second substantial question. Because by then, there was no family court. According to you, I have not checked out.
Lords.
All right. So then the civil court had jurisdiction, isn't it?
Lords.
So A will not. This was dismissed for default. You should have sought for restoration in the court below.
Lords. Only this.
Say it करता है, ठीक है?
That has been rejected. And move a restoration application, Lords.
Where is that restoration application?
That is order, Lords. Running page 8, annexure 3, Lords. It is CMA 7 of 2022.
Sir, order number, page number कितने?
Page number 18.
This is by the district judge.
Lords.
What was the grounds shown for delay, converting the delay?
The appellant has lost the vision and operated his eyes. For that reason, he has not appeared on the date of posting.
Correct. Third Sri S.K. Mahathir, learned counsel for the appellant. Here is the improved order. Yeah, against a second appeal matter, no? No, I don't think so. CMP interlocutory application SAO গোটা আছে second appeal against orders. No. RSA will not lie. RSA will not lie. This will not be a decree within the meaning of section 100. SAO, I think SAO will lie. What do you say, Mr. Das?
I think so.
Is there an order? No, not an interlocutory order. Interlocutory order against
His restoration of the first appeal that was pending has been dismissed, then CMP will lie.
CMP or SAO?
No, SAO remand order.
Remand order against. So this will be CMP. Yeah, please find out. If we find out, we can convert it.
No, appeal that the delay ground reject হইতো তাহলে সেকেন্ড ওভার মেটে নেব
Delay ground হলো
না appeal টা delay ground reject হইছে
মেরিটে ডিসাইড হয়নি সেটা তো নন প্রসেশন ডিসমিস
No, appeal টা আগে হয়নি সে সিএমএ মাটা গোটে ফাইল কলে মাটা that was dismissed for default. তাকু রেস্টোর করে এটা ডিসমিসাল ফর লিমিটেশন সেটা কিন্তু হবো সেকেন্ড appeal. The restoration application which he filed to restore the appeal which was dismissed for default, that has been dismissed on the ground of limitation. Kitne second appeal kinte ho?
Tada to sithi hobani sir, mata to High Court.
Mata ta hitla High Court ko hitana. Mata ta already dismissed for default hegala. He wanted to restore it. That restoration application was dismissed for on the ground of delay. So please examine it again. We'll take it up next week. Matter next week. That's prayed for. Take that, huh?
39 এ ফেলতে কই দଉଛି সেটা আজি সরজাইଥାନ୍ତା রং অপিল এলসিআর টা গুন্থাইছে যে টাইটেল অপিল এলসিআর টা ମୁଁ ଚେକ୍ କରୁଥିଲି ମୋର মেন গোটিଏ গ্রাউন্ড যে আডিশনাল এভিডেন্স টা আଗ কোন
এলসিআর টা কোন আসিছি
তা রং অপিল
করেক্ট এলসিআর টা আসিছি
ମୁଁ ଦେଖିଥିଲି ଆର ଥର ଥିଲା କରେକ୍ଟ ଏଇ ଜେରକ୍ସ କଲା ଭିତରେ ବୋଧେ
এটা ମୁଁ କହିଲି ତାହେଲେ ପାସ୍ ଓଭର କରି ଦଉଛି
ନା ଏଟା ତାହେଲେ 2 ଦିନ ଲାଗୁ ବରଂ ସୋମବାର ନିଆଯାଉ ନହେଲେ ଶୁକ୍ରବାର ନିଆଯାଉ
नहीं वो पास ओवर कले भी शुक्रवार नहीं था किसी असुविधा नहीं लेट हिम फाइंड आउट द करेक्ट एलसीआर
ମୁଁ ଦେଖେଇଛି ସାର୍ ଙ୍କୁ ଯେ ରଙ୍ଗ ଏଲସିଆର ଟା ଗୁନ୍ଥାଇ
ଆସିଛି ବୋଲି କୋଉ
ମୁଁ ଦେଖେଇଲି ସୁଟ ଏଲସିଆର ଟା ଠିକ ଅଛି ଟାଇଟଲ ଅଫ ଏଲସିଆର ଟା ଆଉ ଜଣଙ୍କ ଲାଗି ଯାଇଛି ସେଟା ସେକେଣ୍ଡ ଲେଭେଲ 359 କାର ନା ମୁଁ ଦେଖିଥିଲି ଅପିଲ ଏଲସିଆର ଟା ଦେଖିଥିଲି
नो तो এটা लेट इट बी पास्ड ओवर लेट हिम फाइंड आउट प्लीज हेल्प हिम
फ्राइडे
फाइंड आउट then we'll take it up on Friday.
मोर आइटम 50 टा जो सप्लीमेंटरी लिस्ट रे आपण नोटिस कले एते गोटे डिले अछि 5 डेज और 5 दिन नो
कोथरे आइटम 15 रे
सीएमएपीएल जो
आइटम 50 सप्लीमेंटरी लिस्ट कौन है
सीएमएपीएल फाइलिंग करियो को 5 दिन डिले
नोटिस जीवो कोन
हाँ ये नोटिस जाऊ तादर भी
नोटिस मैं कहथिल नोटिस जीवो नोटिस हिच
ऑन द क्वेश्चन ऑफ डिले
हां से नोटिस जाय नी
हां नोटिस करछन कि डिले ऑन द क्वेश्चन ऑफ डिले
ऑन द क्वेश्चन ऑफ डिले ही जाय थो नोटिस ता IA 227 नोटिस कर दो है ना
हां
item number 41 I have to collect the LCR of the lower court. I may be permitted to collect the LCR, may be taken up.
Kali mention